Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Prosecutor, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Happy Friday. Happy Friday. Today is Friday, February 28th. It's the last day of February 2025. And happy Friday. It's early and we're already up to a couple of droppings to read today. This is going to be fun. Welcome back to the Upside Down, the Inside Out, Narnia, the Matrix, whatever you want to call the debacle that is the Karen Reed case out of Norfolk County, Massachusetts. Fair trial in Norfolk County is an oxymoron. I don't know. What do you think about shirts like that? What do you think about shirts like that? It's crazy. For those of you who were here with me yesterday, we did 4 hours. Kurt from Uncivil Law joined me, and he's a law guy. He's the law guy. He's the guy who knows the case law. He knows appellate work. He knows federal procedure and process. And he broke down the federal habeas petition with us. And we went through some case law that he found to be controlling in the writ of habeas corpus that has been filed by the Karen Reed team in federal court in Massachusetts that will be argued, or at least they're having a conference on Wednesday of next week. We're not sure exactly what they're going to be doing at that conference, whether they're going to be arguing that or not. That is the appellate issue that went up to the SJC and was denied by the SJC. And now there has been a lateral proceeding filed in federal court. So that was fun. And then while we were on the stream, the redacted motion to dismiss broke. So we covered that as well. And that was a good time for those of you who know and were here. I think you had fun. But if you weren't here and you missed it, there's an article this morning in the Boston Herald that I'd like to read to you because for many of you, it's behind a paywall and you can't see it. So while we wait for some people to get here, let's take a look at this morning's article regarding the Karen Reed case in, I think this is the Herald. Hold on. It is Boston Herald. It is entitled Pervasive Misconduct Haunts Case. The font is super small, so I'm going to enlarge it so at least I can read it to you. And here we go. Karen Reed's legal team has submitted a redacted version of its latest motion to dismiss her case on the basis of extraordinary governmental misconduct, primarily the alleged withholding of evidence that could prove her innocence. Quote, now comes the defendant Karen Reed and respectfully moves this honorable court to dismiss all charges with prejudice on the basis of extraordinary governmental misconduct. The 36-page motion states at the top. Lawyers argue that Reed, quote, throughout the course of these proceedings has been severely prejudiced. I lost my place. By the Commonwealth's pervasive misconduct. That includes the alleged suppression of exculpatory evidence, specifically surrounding surveillance footage from the Canton Police Department, which was the precipitating factor for this latest motion to dismiss and makes up the bulk of the motion's arguments. Quote, as a result of this extraordinary governmental misconduct, Ms. Reed has been permanently and irreversibly denied her constitutional right to a fair trial. The motion continued. Reed, 44 of Mansfield, is accused of striking Boston police officer John O'Keefe, her boyfriend of 2 years, with her car and leaving him to freeze and die on a Canton front lawn on January 29th of 2022. For that, she was indicted on 3 charges: second-degree murder, manslaughter while operating a motor vehicle under the influence, and leaving the scene of an accident resulting in death. The motion was filed with the court under seal on Wednesday, with a redacted version released yesterday for the public to see. The motion was first hinted at in a motion filed late January for the state to pay the defense bill for sending out an expert to collect Canton PD footage that the defense team says it was told existed but did not. Special Prosecutor Hank Brennan countered in court that he never made any such promise of its existence, but instead expressed spoken doubts to the defense since so much time had passed. As if they didn't have a duty to preserve it, or 2 court orders to preserve it that were attached to the motion as exhibits that we read yesterday. Defense attorneys filed an emergency motion to preserve evidence on February 2nd, 2022, 3 days after O'Keefe's death and the start of the case against Reed. In the motion, they argue that prosecutors have only produced, quote, dribs and drabs, end quote, of the requested footage and, quote, without any accompanying reports, evidence logs, or other documentation, regarding the recovery and chain of custody of the evidence on at least 4 separate occasions. They further argue that what little was released was at least in part edited, like the instance of a reversed image video shown in court during Reed's first trial last year. The true footage would have bolstered the defense theory, they say. Prosecutors say that Reed struck O'Keefe with her Lexus LX 570 SUV in the early morning on January 29th, 2022, following a night of heavy drinking in Canton and yet another fight between the two in their troubled and jealousy-wrought relationship. Well, yeah, that's their theory. For evidence of this, they point to the vehicle's cracked and broken right rear taillight, which allegedly broke with the force of smashing into O'Keefe. She subsequently, prosecutors say, left him to freeze and die on the front lawn of 34 Fairview Road in Canton, the home of fellow Boston police officer Brian Albert. The defense counters that O'Keefe made it into that house, was beaten to death inside by others, and then dragged out to the front yard. They say that local police and prosecutors worked to keep suspicion away from Albert and his party attendees and to frame Reed, including by sprinkling pieces of her taillight on the front yard to be found days after the incident. Not just days, but I think weeks went by before more evidence just magically started revealing itself. The defense motion states that prosecutors knew that critical video was inverted and used it to insinuate that disgraced former MSP trooper Michael Proctor had instead been around the rear left taillight of the car as it was at the Canton PD garage as evidence when, quote, Proctor was in fact standing directly next to the right rear taillight and thus capable of meddling with it. Quote, to this day, the Commonwealth's failure to explain the disturbing circumstances surrounding their disclosure of the exculpatory Sallyport video and why some video was suppressed from the defense at the first trial has made a mockery of Ms. Reed's right to due process, the motion states. The defense seeks an evidentiary hearing on its arguments that would require testimony from the first trial prosecutors, Assistant District Attorneys Adam Lally and Laura McLaughlin, as well as new Special Prosecutor Hank Brennan, MSP Norfolk County Homicide Chief Detective Brian Tully, Canton Police Chief Helena Rafferty, Trooper Proctor, MSP Sergeant Buchanan, and others. Excellent reporting, in my opinion. And we go back to the chat. All right, we're not talking about anything regarding donuts is going to be deleted, just so you know. Thank you for playing. Have a nice day. Let's do this, says Vixie Blaze. Just a girl from Fall River's been here for a month, and she's from Fall River, I think. Thanks for joining. Beth Huntley became a new member. Welcome, Beth. Welcome. Fraka, thanks for your 10. The Commonwealth submitted the opposition motion. Yes. Yes. He says it was the same as what the defense submitted, just inverted. Oh, I see what you did there. Well done. Well done. The snark tank is on fire already. Did I bite him? Yeah, I bet him. I ordered my sweatshirt yesterday and it shipped already. I can't wait. Oh, that's amazing. I'm so glad to hear that. I'm so glad to hear that they have good fast customer service and shipping. That's amazing. I'll show you guys the merch in a sec. If you weren't here yesterday, you may want some. Marissa, good morning. Just want to say I appreciate you. Oh, well, I appreciate you even more. Thank you, Marissa. Thanks for the 5. Mrs. Bouquet has been here for 10 months and says she's loving my channel. Thank you. The world is watching, Auntie Bev. It's been here for 3 months and says you wanted to thank me. I thank you right back. Without you guys, I'd just be sitting here screaming at my TV. Tracy Walker gifted 5 memberships. Thank you, Tracy, as always. And to those 5 new members, I think you're going to like it here. Erica became a new member. Welcome. Abacus Lynch, thanks for the 20. Says, my opinion is that the only way Bev denies the defense's motion to dismiss is if she doesn't view the metadata chain of custody of the Sallyport video isn't exculpatory. Playing devil's advocate, how can she make that argument that it wasn't? Well, we saw a motion to dismiss during the first persecution of Karen Reed, or actually before in the pretrial. You can go back to my pretrial playlist and see that. How could she make an argument that she shouldn't have been recused? We went over that decision also, I think, last Saturday stream. We're in the upside down, Abacus Flinch. Do I need to remind you? It's a crazy town that we're in. I agree with you, of course, but who knows? Linda, thanks for the 5. Good afternoon. Love from Scotland. Scotland is here. The world is watching. Dawn Burke is thanking me, and I thank you right back. Good morning, Wine Yogi. Good morning. Happy Friday from Switzerland. Switzerland and Scotland in the house, at least so far this morning. Hi, Nina. Sharon is the president of the Rage Crochet Club in chat. So if you guys would like to, yes, I'm aware. Ha ha ha. Thank you. I have all of the motions ready. I've got them all. Has been here for 16 months. And if you'd like to rage crochet, you may commence, all of you. Ha ha ha. Says there's a defense for delaying the motion to dismiss argument. Thank you so much. I have that motion as well. You guys, I'm on top of it. I'm on top of it today. There's a motion. We have the opposition from the Commonwealth. And then we have motion to amend the scheduling order. So we're going to look at both of those. And while we're here, I'm sure that some other things are going to drop. And look, Germany's here, Romania's here, Finland. 2 Finlands are in the house. And there it is. Boozy Beauty put out a new video today. Great. Dublin is here. All right. Let's take a look and see what the Commonwealth has to say for themselves. For those of you who didn't watch the stream yesterday, it was good. And if you want to catch up and go through an entire reading of the entire motion and Alan Jackson's affidavit in support, we did that yesterday. Don't go now, though. Go later. All right. Moving on. Okay, got it. This is also redacted. This is redacted as well. The world is watching. Peeps, friends, the world is watching. We are at docket number 526. Docket number 526. I try to put the docket numbers and the timestamps in the video description after we're done so that if you ever want to come back and review a certain portion of it, the timestamps will be there for you. And it makes it easier to find things and stuff because there's so much things and stuff in this case. There are so many shenanigans afoot. The tomfoolery and ballyhoo is simply off the charts. And you know it is because you've been here with me for a very long time. All right, what just happened to my StreamYard? Is acting up. Hang on. There we go. All right, on delay. Commonwealth's opposition to defendant's motion to dismiss for extraordinary governmental misconduct. Just fix this over here. Talk amongst yourselves for 1 little minute. Okay. Get my red pen out because girl's got to have her red pen. Now comes the Commonwealth, and this was stamped. This was stamped today, the 28th. It was due yesterday, but they may not have stamped it until today. 8-something a.m., 8:49 maybe. Can't really read it, but look at us being right on top of it. And I scheduled this an hour ago, so here we go. Now comes the Commonwealth in the above captioned matter and submits the following in opposition to the defendant's renewed claim that her indictments should be dismissed because of egregious governmental misconduct. And, they put it in quotes because, they don't believe it's true. The Commonwealth disputes any ethical violations or misconduct, let alone misconduct that taints the legal system or infringes upon the defendant's right to a fair trial. The defendant's motion should be denied. Dismissal as a sanction is, quote, very strong medicine, and it should be prescribed only when the government misconduct is so intentional and so egregious, end quote, and appropriate only upon a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Spoonful of sugar helps the medicine go down. We think in song lyrics here, even show tunes. Citing Bridgman versus the district attorney for Suffolk District, which is a Massachusetts case from 2017. To the extent the defendant has suggested that egregious circumstances might warrant dismissal, the Supreme Judicial Court has noted that, quote, we have never dismissed charges in such circumstances in the absence of prejudice. Oh, that's funny. So you think you can just withhold exculpatory video for as long as you want? Try somebody once, cause a mistrial, or a mistrial is had, and then you can say that there's no prejudice to the defense because maybe she would have been acquitted the first time if you turned over the exculpatory Canton PD Sallyport video. Maybe she would have been acquitted. Judicial responses should be limited to, quote, truly remedial and not punitive measures. Well, we'll see about that. Hang on. I'll get continuous scroll going here. The Commonwealth does not dispute its prosecutorial obligations and constitutional duty to disclose in a timely manner material, exculpatory evidence over which it has possession, custody, or control. See Brady v. Maryland. And in re, in the matter of a grand jury investigation. Nor does the Commonwealth dispute its broad obligations to inquire and disclose any facts that would tend to exculpate the defendant or diminish her culpability in all statements of witnesses. See Commonwealth v. Ellison, 1978 case. The Brady obligation comprehends evidence which provides some significant aid to the defendant's case. However, to prevail on a claim that the prosecution failed to disclose exculpatory evidence, the defendant must first prove that the evidence was, in fact, exculpatory. Well, kind of hard to prove it when you blur out the section of the taillight in question in the video that you turned over like last week with no metadata. Awfully convenient, isn't it? Exculpatory evidence includes all evidence that tends to negate the guilt of the defendant or, quote, provides some significant aid to the defendant's case, end quote. And while rightfully broad, the conception of exculpatory evidence is not boundless. Citing McFarland, which is one of the judge's favorite cases because she talks about McFarland a lot. McFarland and Graham. Canton Police Department surveillance video. In 2022, the Commonwealth provided the defense with approximately 90 crime scene services photographs depicting the condition of the defendant's vehicle in the Canton Police Department Sallyport. Yeah, after the taillight was smashed. And didn't crime scene services not even show up to the Canton Sallyport garage until a couple of days later? That's funny. And you know what else is funny now that we're talking about the crime scene services department? Why didn't they respond to the scene at 34 Fairview to start collecting the evidence instead of the CERT team? Because you and I looked at together the duties and responsibilities of the CERT team, and that includes searching for missing persons, crowd control, and some other things, but they're not in the business of collecting evidence. That's the crime scene services department. They didn't show up in the snow outside 34 Fairview after Karen Reed's Lexus was seized and brought to the Sallyport to start finding portions of taillight because they were told exactly what to find. You're going to be looking for some taillight pieces and a sneaker. And here's where you're going to be looking. And then, miraculously, in their shoulder-to-shoulder grid search that only encompassed about, I don't know how many feet, but it wasn't very wide, not what they're used to in a missing person search, they miraculously found a couple of pieces of taillight and a sneaker. And then they were able to stop. And then the CERT team even said to the MSP, we can come back, once the snow starts melting and stuff and look for some more evidence. They're like, no worries, bro. We got this. But, please, Mr. Brennan, don't dislocate your shoulder patting yourself on the back that you turned over 90 crime scene services photograph depicting the condition of the vehicle. So the only thing you took pictures of is the taillight after you came into possession of the car. A couple days later. I mean, wild. Further provided to the defense was ring surveillance video of the defendant's broken rear taillight at approximately 5 a.m. Really? This is a great soundbite for the media. But the ring surveillance video from the driveway at One Meadows when Karen's backing out of the garage shows her backing into John's Traverse and then pulling away, and certainly does not show a shattered taillight at all. Way to mischaracterize the evidence. Statements of witnesses who observed the defendant's broken taillight. Yes, right. Jennifer McCabe, around 5:30 a.m. Oh, you know what's so funny about that too, Mr. Brennan? Because we know you didn't watch the first trial. You know what's so funny about that is that on the stand, Jennifer McCabe said, when we got back to One Meadows, Karen took us around to the back of the vehicle to show us her shattered taillight or broken taillight. And we watched the video of them arriving at One Meadows. And you know what didn't happen? They didn't go around and look at the right rear taillight. No, they didn't. They ran into the house. And you know what happened next? Well, I know you might not know this part because you didn't watch closing arguments. But your water boy, Mr. Lally, who's really in a lot of trouble right now, he's in a little hot water. Hot water boy. Oh, we can call him Hot Water Boy. Hot Water Boy said in his closing, Karen Reed, upon entering One Meadows, this is like summarized, it's not exactly what he said, went inside that house and she knew that John O'Keefe wanted people to take their shoes off when they came into the house. She didn't take her shoes off. She didn't take her shoes off that morning because she knew that he wasn't coming home because she killed him. And therefore, she's guilty. Wow. Wow. Okay. Statements of witnesses who observed the defendant's broken taillight at 5:30 a.m., like Jennifer McCabe. Okay, cool. Again, can we have some Thompson twins in the chat? Lies, yeah. Canton police cruiser video depicting the defendant's broken taillight at approximately 8 a.m. Wow, this is another great soundbite for the media. Take it from me. They showed some video in court of some officer going to do a wellness check at One Meadows, which I submit to you was completely unnecessary because everyone knew where the children were. They didn't need there to go do a wellness check on the children. Everyone knew where the children were because it was testified to, and the police were told that the niece had been picked up and that the nephew was on a sleepover that night, so he wasn't home. Oh, so they went to do a wellness check and they have some dash cam video that they showed in open court, and it was like a big cliffhanger, and we're all waiting. We're all waiting to see what they're going to be showing us. It's not what it showed, and nobody testified to it that it was broken. Nobody authenticated that. Nothing. There was nothing. Just completely misstate the facts and the evidence, Mr. Brennan, because if you have not violated ethics already, dip the toe into the water of hot water boy, because water's fine, apparently. Observations of a damaged taillight by the Dighton police. Yes, Officer Barrows said it was cracked. What were his exact words? Anybody know? Officer Barrows. And automated vehicle location data from troopers' cruisers who were assigned to the CERT team, evidencing that the CERT team was on Fairview Road before the defendant's vehicle arrived at the Canton police station. Really? Notice that he doesn't put any detail in there. Automated vehicle location data from troopers' cruisers. Did anybody see that? Automated vehicle location data from the troopers' cruisers. Did I fall asleep during some part of Lally's direct examination of any witness? Olivia, are you here? You're going to have fun with this later. Here's the thing about when Karen's vehicle arrived at the Canton PD. You haven't been turning over all the video. The video that you did turn over has the one in the middle of trial anyway, it was inverted. The timestamp was a different color than everything else. And, who knows what was tampered with because, you don't have any metadata. You don't have any metadata. I mean, I think you really maybe kind of should have watched the trial. Lieutenant Kev, you know what else? You know what else the CERT team had or didn't? Who was in charge of the CERT team? Was it O'Hara? No logs of who was on scene at 34 Fairview. No logs. In fact, whoever that was in charge of the scene and had like HQ set up in his car, I think, was asked if there was a log of, who was on scene. They're supposed to have a log. They're supposed to say who got there, what time, who was on scene. He said there were at least 3. He may have said 5 people, men on the scene in plain clothes. He assumed they were with law enforcement, but he doesn't really know. He doesn't know what time they got there. He doesn't know who they were. And, no big whoop. No big whoop. Lieutenant Kevin O'Hara of the Massachusetts, it is O'Hara, there we go, sorry. Of the Massachusetts State Police CERT team testified at trial. And his automatic vehicle locator, AVL records, confirm his arrival at 34 Fairview Road on January 29th, 2022 at 4:56 p.m. Lieutenant O'Hara additionally testified that his arrival was preceded by one other trooper from his unit, Trooper Jason Beausoleil, at 4:54 p.m. You know what else I remember? And I forget who testified to this. Maybe it was Saraf, that the times on the dispatch log were wrong, as were the times that everyone arrived on scene. But no big whoop, because the most important thing is that we got to the scene. Doesn't matter that the times were wrong. Yeah, this is evening. Yes, this is PM. Yes, this is after the scene was left unattended from the time it was cleared a little before 8 a.m. by the Canton PD until what they're saying is 4:56 or 4:54 p.m. It was left unattended for the entire day. They didn't have anybody sitting there in a cruiser to make sure nobody came on scene and, you know, magically did anything. They didn't rope off the scene with crime scene tape because, it was windy and snow. And so it was unsecured from 8 a.m. until 4:54 p.m., according to their papers. Bringing you wrong, says Tennessee cousin. And here's the transcript. Day 25, June 3rd, pages 13 and 14. All right, we have to go back to that. The defendant's vehicle arrived on the back of a flatbed tow truck at the Canton police station at 5:30 p.m. Maybe it did. Maybe. You haven't turned over all the video, apparently. The defendant has also repeatedly represented in the media and postured at trial that her taillight was broken at 5 a.m. by striking the victim's parked vehicle in the driveway of the victim's house. The Commonwealth has provided substantial evidence, including accident reconstruction video from its expert, Judd Welcher. Well, we don't have that yet. And do we even know if he's going to be allowed to testify at trial? Is he going to be Trooper Paul's replacement? Trooper Paul, you've been replaced. Demonstrating otherwise. Oh, another great soundbite for the media to run away with. Beyond unsupported claims and vague innuendos, the defense struggles to establish how the condition of the defendant's broken taillight in the Canton PD Sallyport is in fact exculpatory or, quote, the most critical and highly contested issue in this case. Well, really? Again, maybe you should have watched the trial because it's the only alleged evidence that John O'Keefe was hit by a car, because his injuries certainly do not tell that story. We all saw her car hit it. We did, green-eyed Southern girl. We did. Despite claims to the contrary, the defense never filed a motion to preserve, or in its perpetually evolving theory of the case, did the defendant specifically request prior to November 2024 surveillance video from the Canton police station. My head's going to pop off. My head's going to pop off. And because I have the rules of professional conduct pulled up for prosecutors, and you should be outraged. If you are not already outraged, join in the outrage. The defense never filed a motion to preserve. I'm sorry, did you not read the original papers that have 2 orders to preserve? 2 orders from 2 different judges? Aside from the fact that it is your affirmative duty, you don't need a motion, you don't need an order. I know that you're usually a defense attorney, but this is the standard that prosecutors are held to, sir. It's so basic. It is so basic that this is things that are automatically supposed to be done by the prosecution side, that it is an embarrassment to read this to you. Really, it hurts my soul as an attorney. And like Kurt and I were saying yesterday, is this day one on the job? Is this footnote number 1, which says the defense claims their February 2nd, 2022 request for, quote, all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene, end quote, was sufficient notice to the Commonwealth to preserve footage from the Canton Police Department Sallyport video, or Sallyport, where the defendant's vehicle was stored for approximately 2 days. The Canton Police Department is not the alleged crime scene. Oh, yes, it is. You know what's so funny about that? You know what's so funny about that, Mr. Brennan? You really, really, really should have watched the first trial, because during that time, I think it was Proctor who was cross-examined on the fact that he went to the scene. And he said, well, what scene? There were a lot of scenes. Scene didn't really mean 34 Fairview, according to your own investigators, Mr. Brennan. Was it Proctor who said that? Right, right. So when Proctor says he went to the scene, he meant the Sallyport. But he's saying here, the Canton Police Department is not the alleged crime scene. No, it was Garino. Letter O's by Better O's says it was Garino. Yeah, the scene at the Canton PD, right. Like he obtained John O'Keefe's phone at the scene. There were a lot of things referring to the scene. And then they said, well, right. Coffindoffer said the Canton PD was the scene. Mm-hmm. If a crime was committed there with regard to the condition of the alleged murder weapon, then it too would be a crime scene. I mean, what? Oh, I can't wait for the reply. The Commonwealth could not reasonably have anticipated the defense's ever-evolving third-party culprit claims, nor to this day made the Canton Police Department video pertinent to their amorphous and fluid claim. If you see like my head pop off and blood spouting everywhere, just, tis only a flesh wound. No worries. No worries. Nevertheless, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department Sallyport until receiving the federal grand jury transcript of MSP Trooper Michael Proctor. Really? Really? So Trooper Proctor had the knowledge all along, and you didn't know? It's your job to know. It is your job to know. You didn't know there were cameras in there until Michael Proctor testified in front of a federal grand. You didn't know? Their knowledge, since they are an arm of the Norfolk County District Attorney's Office, they are imputed to be employees of you, and so therefore they're an extension of the Norfolk County DA's office, and their knowledge is imputed to you. That's how that works. See? Is he going to wriggle his way out of that too? How would you not know? Prior to that, the prosecutor had not been alerted to its existence by investigating officers. Well, whose fault is that? So here's his defense. We didn't know. We didn't know there were cameras there. We didn't know that the Sallyport had cameras. We didn't know there were videos. We didn't find out until we got the federal grand jury transcript of Proctor. So when was that? That was during the document dump by the feds. I see. So you never inquired. You never. Because why? Because Michael Proctor wanted to hide from you the fact that this video existed, hoping you'd never ask for it, hoping nobody would ever find out about it. Why did they move it? Why did that retired detective DGM Pietro start moving stuff off the system, putting it onto some random hard drive and or iCloud that we really don't even know, thus deleting the metadata and not preserving it in its original form? Promptly on August 4th of 2024, promptly, more than 2 years after the murder of John O'Keefe. He says, promptly on August 4th, 2024, the Commonwealth provided the defendant with 9 surveillance videos in its possession. Wasn't that in the middle of jury selection? Consisting of video footage of the main driveway of the Canton Police Station and video files entitled O'Keefe Sallyport 12822. Well, why 12822 when you didn't come into possession of the car until the 29th? 12 a.m. to 12 a.m. O'Keefe Sallyport 129:22 from 12 a.m. to 5:30 p.m. Okay, so this is main driveway footage. Somebody saved it, but they never told you it existed and they never gave it to you. Can anybody say Adam Lally's going to be called to the stand and have to answer to this? Because Hank Brennan is the one drafting this affidavit. Is there an affidavit attached to this from Lally? Because I'm dying to know. Because he's the only one with personal knowledge of this. Because he was the one who was trying the case on April 4th of 2024. So that'll be interesting. And you can't cross-examine an affidavit anyway. So, Mr. Lally, can you hear me? Are you prepping your case right now for the testimony that you're going to need to give? Have you hired a lawyer? O'Keefe Sallyport 129:22 from 5 p.m. to 12 a.m. O'Keefe Sallyport 130:22, doesn't say what times. O'Keefe Sallyport 131:22. O'Keefe Sallyport 21:22 from 12 a.m. to noon. O'Keefe Sallyport 21:22. I'm sorry, 21:22 I meant. From noon to 12 a.m. and O'Keefe Sallyport 22:22. Yes, the day that Karen was arraigned in Stoughton District Court. Oh, please. Okay, Scott, I'm not sure if this is, maybe you could send me the link to that instead of the screenshot. That would be so awesome. Thank you. Okay. If you already read it, no spoilers, please. Julie is not going to spoil it. She says, brace yourself on this one, roller coaster, webs, lies, and hidden truths. It's a circus. Thanks, Julie, for tuning in from down under. Notably, the quality of the video is poor in certain portions. Oh, Hank's admitting that. In certain portions, yeah, the portions that involve the tail light or people around the tail light. However, that is the condition it was recorded in and the condition in which it was received by the prosecutor. Really? Show me the metadata. The Commonwealth has produced evidence that since January 2022, Sallyport camera was replaced due to its defective condition. And during the first trial, the Commonwealth called the technology director for the town of Canton to testify about surveillance video systems throughout the town. And he was subject to cross-examination by the defense. What? I'm sorry. Are you talking about Louis Jutras? Did anybody remember hearing, because this is all new? Anybody remember hearing that since January 2022, the Sallyport camera was replaced because it was defective? I'm sorry. That's right. He said he didn't remember the disc. They handed him a disc, Kelly Cal. Louis Jutras on the stand, they handed him a disc. I thought he was the town of Canton, right? He was the town of Canton. IT guy. Lally handed him a disc and said, do you recognize this? And he said, well, I've never seen this. But Lally tried to rehabilitate him by saying, but isn't this what you turned over to us regarding the video at the library? Because I think he only testified about the library video. And he said, no, I gave it to you on like whatever other format, like a flash drive or something. He only testified about the library video, right? And he said he didn't. More Brady violations, says Green-Eyed Southern Girl. So his argument here is that Louis Jutras was on the stand. He could have cross-examined him, even though we didn't bring out on direct that the Canton Sallyport camera was defective and had been replaced. But you could have read his mind. This is a new lie, says Billy Marie. What? He was subject to cross-examination. You could have asked him. You could have asked him. He didn't testify about the Sallyport video at all. He testified about the library video. Again, Mr. Brennan, you really, really, really should have watched the trial. I mean, for us, it was almost a year ago, and we still remember. This is the Brady Bunch, Lady Zelda. It's the Brady Bunch. There's so many Brady violations. It's the Brady Bunch. He's making this argument in good faith. When did you produce this evidence that since January 2022, the Sallyport camera was replaced due to its defective condition? Feel free to chime in and correct me in the chat if I'm wrong. But I don't remember ever hearing anybody testify during the trial that since January 2022, the Sallyport camera was replaced because it was defective. Thanks, Kelly. You just can't. You just can't make this any ducking stranger. Okay. No spoilers in the chat. But I got more information for you. We got another document for you. Anybody remember that? No, not mentioned ever. Calm down, Tinkerbell. You talking to me? Because I do love Tinkerbell. That was not mentioned ever, and not even last week. Why? Yes. Shh, don't tell. Shh. Then why would they not say that when sending experts to look at the system? Right. It's a different camera system now. I can't even believe what I'm reading right now. The Commonwealth filed its certificate of compliance on April 10th of 2024, noting that, quote, to the best of its knowledge, and after reasonable inquiry, it had disclosed all information subject to Rule 14. Well, you're contradicting yourself now because you just said the first time you ever found out that there even was any Sallyport video was when the feds turned over all of those documents. And that was prior to the trial because Josh Levy was on a conference call with Lally and the defense attorneys and said, in good conscience, I can't allow this case to go to trial. He was the U.S. attorney for the District of Massachusetts at the time. And he said, therefore, I'm dumping 3,074 pages on you. And I have qualms about what reasonable inquiry means. Because it was over 2 years that video was in the possession of Canton PD and the MSP. And what, you never asked? So you didn't get it? Oh, that's funny. Kind of like how you're making the argument that they didn't specify in the motion that all Sallyport video needs to be preserved, and so therefore, you didn't have to preserve it. Okay. The parties were in court on Friday, April 12th, 2024, to argue motions in limine. Call them motions in lemonade. Uncle Fredo's going to start drinking. Duck it. This is unreal. Margaret, are they living in another world or something? Yeah, no, they were living in the upside down. Everything's mirrored there. It's almost like, you know what it's like? Call me Alice, because I have like Alice merch that says it strains credulity. It's like we're at the Mad Hatter's tea party. We're in the rabbit hole. We're all the way through the back of the wardrobe into Narnia. We have really entered another dimension. During the defense's televised motion to admit 30-party culprit evidence, Attorney Yannetti made representations about the Canton Police Department surveillance videos. A lot of motions were televised, sir. Following that hearing on April 17th of 2024, Lieutenant Brian Tully sent prosecution team members an email stating, oh, I can't wait to see that email. Quote, I spoke with Chief Rafferty. She reviewed the video of the SUV arriving at Canton PD. Exists, and we should have it, contrary to what defense represented on Friday. What? Hold on, I got to read that again because my head is going to pop off again. She reviewed the video of the SUV arriving at the CPD. Exists. That's not even a proper sentence. And we should have it, contrary to what defense represented on Friday. So he's saying, Tully is saying, I talked to Chief Rafferty. What do you mean we should have it? Meaning you already turned it over to the prosecution? Or Lieutenant Tully has it, so we're now going to give it to you? Every single one of these jackholes is going to be called as a witness in this evidentiary hearing. Every single one of them. The video depicts the vehicle entering the Sallyport and crime scene tape being put up. Oh my God, they found the crime scene tape. They didn't. So is it the crime scene or not? You just said it wasn't the crime scene, but now you're putting up crime scene tape around the vehicle. So somebody thought it was a crime scene. You know where you didn't put the crime scene tape? Around the actual crime scene on the lawn of 34 Fairview, where a dead brother in blue was. You didn't outline his body. You didn't put up any evidence markers. You didn't take any duck and photographs or measurements or anything like that. And then you left the scene unattended for 8 hours while, 18 more inches of snow fell? Kelly says, I just watched O'Hara's testimony. He didn't arrive until 5 p.m. at 34 Fairview. I think, what did they say, 4:56? Thanks, Kelly. Yeah, Glenn's like, put crime scene tape all around Canton. Yep. And then Telly goes on to say in his email, she is putting it on a thumb drive for us in the event that we don't have it. Well, when he says we, doesn't that indicate to you that he and Lally were we? See Defense Exhibit G. Okay, Defense Exhibit G? No, we want you to attach that email to this motion as an exhibit. That's what we want. That email with the actual metadata. You're going to send the judge back to go look at Defense Exhibit G, which is the thumb drive. Again, not in its original format. Yep, Magnolia Gypsy, the Sallyport video camera has also been rehomed. Yep. The prosecutor has not, the prosecutor had not previously received this video or knew of its existence. Oh, that is rich. Subsequently, the prosecutor requested that both the Massachusetts State Police and the Canton PD produce all relevant and material surveillance video. Oh, it wasn't until the trial was ongoing that the prosecutor requested that they turn over the surveillance video. You know, I didn't think that Brennan could make this any worse for himself and Lally and McLaughlin. I didn't think he could make it any worse for them, but he's making it 100 times worse for them. Do you see it? It's literally their job. They have one job. It is literally their job. How did you upgrade the charges to murder? Are you kidding me? Yeah. How did he request it? What is there an email? Right. Great point. Where's the receipts on that? How did he request it? Smoke signal? Email? Phone call? Fax? On April 23rd of 2024, the Commonwealth provided the defense with surveillance video entitled Interior Sallyport Back Wall with a bunch of numbers. And then there's nothing after that where there should be a dot. Remember, .exe is what I think we saw in some of the video yesterday. And you guys who know IT are like, exe, that's not the original format. It's been proctored. Morse code. Yeah, did they do it in Morse code? Text messages, right? Notably, what was produced to the Commonwealth and provided to the defense was inverted surveillance video footage due to the camera's settings. Oh, really? The camera that has been rehomed. It doesn't exist anymore because somebody switched the settings on the camera. I call bullshit. Bullshit. The Commonwealth did not manipulate or alter any video and entered as a trial exhibit the video in the condition it was received. Contrary to the defendant's well, then if you received it that way, somebody did alter it and manipulate it, and we need to know who, and they're going to be questioned on the stand, and everybody better show up with counsel because tampering with evidence is a crime. It's a crime. I hate to tell you, but it's a crime. And entered as a trial exhibit the video in the condition it was received. Wasn't me. Wasn't me. Yeah, prove it with the metadata. Contrary to the defendant's representation that the Commonwealth's intention was to mislead or deceive the jury by introducing the inverted video, the defendant fails to mention that after the defense altered the evidence to correct the image, in quotes, correct, and also inverted is in quotes here, by introducing the quote inverted video, the defendant fails to mention that after the defense altered the evidence to quote correct the image to appear consistent with the human eye, the Commonwealth played the entirety of the quote corrected yet altered video. Oh, so now you're accusing the defense of altering your video. Craig Bates has entered the chat. Tiny Desk Man has entered the chat because he was able to flip the orientation of that video, probably on his laptop, because it's probably, I can do it. I can do it on my MacBook. And now the defense is altering the video. Oh, that is rich. That is so rich. To correct the image to appear consistent with the human eye, the Commonwealth played the entirety of the quote corrected yet altered video, which reveals that Trooper Proctor is standing feet away from the defendant's vehicle and never touched the rear taillight. Oh my God, how much video is missing? First, Buchanan said that was Proctor, that was me, and then on cross, now all of a sudden he doesn't know. When the video is corrected to its regular orientation, then all of a sudden Buchanan doesn't know who's who in the video. The world is watching. This is outrageous. This is some Baldwin level BS. And I'll submit to you, this is worse. It's worse. Just when you thought it couldn't get worse, it's worse. How's the other side going to spin this? How's the Karen Reed is guilty, we should hang her in town square side gonna spin this? It's good enough. Metadata doesn't matter. Clearly, you can see in this very, very blurry video, Proctor doesn't go near the taillight. However, there's so much video missing that we don't even know, because we never even knew the video existed until the trial happened. Further omitted from the defendant's filing is the fact that Trooper Proctor's DNA was not on the right rear taillight. What? Oh, my Lord. Flying monkeys are here. The flying monkeys have entered the chat. Remember that during some point during the pretrial, and we covered it, Buchanan and Proctor gave DNA samples so that it could be, ruled out of evidence and such things like as that. And then they did say, or somebody said on the stand, that the red-brown stains on the jeans of John O'Keefe had, they contained some of John O'Keefe's DNA, and two unknown male contributors that were not, but they were able to rule out Proctor and Buchanan. But we don't know who the other two male contributors to the red-brown stains on the jeans of John O'Keefe was. Right, neither was John's. I don't know. What if somebody was wearing gloves and used a hammer? Because you couldn't really break that taillight, that cracked taillight. You couldn't break it into big pieces with your bare hands, could you? When you need some sort of weapon or tool, like a hammer or a crowbar or a sledgehammer. Peter Gabriel has entered the chat. Sledgehammer needs to go on the playlist. After the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office Well, because it was really cold. Somebody, if you feel like having a little fun, go back to that interior Sallyport camera and see who was wearing gloves. Or if you can even tell who's wearing gloves, if anybody's wearing gloves. Because it was cold. They had winter hats on and stuff. After the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office reviewed the surveillance footage that had been previously produced to the defense. Okay, who? Who's that person? Who's the certified forensic video technician? You got a name? Recognizing that the video was extremely dark with minimal visible detail, the video technician clarified the video footage. Oh, good. So you altered it. And on October 10th of 2024, the Commonwealth produced to the defense clarified videos with no metadata. Again, it's like now the 10th generation of this video, but now it's clarified. Reports detailing the forensic clarification process, associated hash values, and extracted still images from the Canton Police Sallyport. Okay, who's the video technician? Because they're going to need to be called as a witness during this evidentiary hearing too, is manipulated again. Furthermore, the video technician clarified video images from the Canton Police Cruiser camera footage on January 29th, 2022 at 8:23 a.m. Oh, the one for the wellness check that was unnecessary. Cool. So you edited it again. So you manipulated it again. So and of course you have no metadata on that either, right? Yeah. The Canton Police Department interior Sallyport front wall footage from January 29th, 2022 at 6:13 p.m. What happened at 6:13 p.m.? What happened then? Or that's what you turned over. That's what you turned over in October. Oh, all of this stuff was turned over in October of 2024, long after the trial was over. 3.5 months later. Duck the pink shirts. Joanne says, you can spot all of us Karen supporters because our heads have popped off. Yeah. Again, don't dislocate your shoulder patting yourself on the back, Mr. Brennan, because after you got involved, all this stuff started magically appearing. And the Massachusetts State Police Crime Scene Services section photographs from February 1st of 2022. Oh, so that's when they took the pictures of the car, February 1st of 2022. Okay, cool. Each depicting the same damage to the right rear tail light and encapsulated those images in a substantive report provided to the defense. Well, congratulations to you. Whose report was that? They turned over a report. Was it Colleen Crawford's report? But again, he's very intentionally not naming her in this motion. After trial on August 21st of 2024. Okay, so now we're going back in time. He was just talking about what they turned over in October 2024. Now he's going back in time because, chronology is not a thing. Methodology is not a thing either. The Canton Police Department provided the Commonwealth with 2 additional videos. Oh, of course they did. Video from the interior Sallyport camera on January 1, 2022. Depicting that the camera captured all video in an inverted fashion to rebut the defense's suggestion that the video had been tampered with. Yeah, or you tampered with all of them. But we'll never know because we're not entitled to metadata. That doesn't rebut anything. But go on with your bad self. And consistent with witnesses' trial testimonies, video from the interior hallway and exterior of the Canton Police Station that shows Brian Higgins at the Canton Police Station during the early hours of January 29, 2022, and depicts Mr. Higgins moving his law enforcement vehicles due to the snowstorm. What car did he drive there? What car did he drive over there to the Canton PD? Inquiring minds want to know. What clothes was he wearing? Or did you lose that video too? Did the video show him pulling up? What car did he drive there? There's been some speculation that he may have driven not a white Jeep with a snowplow, but perhaps a Ford Edge? I don't know. I'd love to know. I'd love to know. Because why did they keep talking about his Jeep during the entire trial? They never really tied together. They never really closed the loop on that. I don't know. How many times has this been done to others? May wants to know. About 8,000 of you here. I would love it so much if you guys would hit the like button. Share the video. That would really be a sweet thing to do. These videos were provided to the defense on October 10th of 2024. Okay, why? Why did you turn them over on October 10th of 2024 when you allegedly were in possession with them since August? Why did it take you nearly 2 months to turn them over? Along with a letter from the Canton police chief noting their August 21st, 2024 production. Oh, so we're going to turn them over to you like almost 2 months later, but we're going to give you a letter from Helena Rafferty saying that she gave them to us in August of 2024. Prior to their production, the prosecutor was unaware of the existence of these videos. Who's hiding what from who? The defense boldly claims, there's one bold person here, and his name tag is up in the corner of your screen. The defense boldly claims that the surveillance video of Mr. Brian Higgins in and outside the Canton police station proves that he, quote, perjured himself before a federal grand jury. This claim is extremely prejudicial and false. In support of this claim, the defense cites to a federal grand jury transcript. Now it's redacted. That's redacted until the end of that paragraph. So it must have been whatever Higgins said in front of the federal grand jury. Does anybody get the sense that perhaps they're going to be throwing Higgins under the bus this trial? I don't know. Just a little inkling. Further, the defense is unable to demonstrate any prejudice. Really? You mean like like a complete sham of a first persecution that ended in a mistrial? You better be praying to God every night and thanking the good Lord, Mr. Lally, Ms. McLaughlin. Karen Reed was not convicted. You should be thanking the Lord every day that she is not in jail right now and that she's out on bail. You really should be. Because if you thought that your county was going to be bankrupt after this is all over before, now it could be the entire state. This is insane. The defense is unable to demonstrate any prejudice. I don't even know what to say. Both Brian, and then there's a redacted portion, and then it says both Brian Higgins and Brian Albert were thoroughly cross-examined at trial about their phone calls with one another. Yes, that's true. Their phone calls with one another that they called butt dials. Brian Albert was having sexy time with his wife, and he happens to keep his phone in his bed with him, so he rolled over or did something. And he butt dialed Brian Higgins, and then Brian Higgins was home sleeping on his couch. He doesn't remember nothing about nothing because, he probably had a couple drinks and something to eat when he got home. A couple more JMOs and gingers. That's not what we're talking about here. We're talking about the fact that he testified that he didn't make any, he doesn't remember any phone calls in the early morning hour, January 29th, not specifically just the phone calls between him and Brian Albert. Additionally, the Commonwealth provided the defense with 167 pages of access card swipe records throughout the Canton Police Department on January 29th of 2022. When did you turn that over? Because I submit to you that if you had 167 pages of card swipe records in one day, January 29th of 2022, then you sure as duck knew that there was a camera surveillance system inside the Canton PD Sallyport. Or do you just have plausible deniability about all of it? Mr. Higgins was cross-examined about his movements through the Canton Police Department on January 29th of 2022. What does that have to do with anything? We're talking about him specifically being on the phone 1:34 or 1:36 a.m., whatever time it was when he was walking out of the Canton PD after he lied and said he doesn't remember any phone calls in the early morning hours of January 29th. And then he did, because they made a motion for his cell phone records pre-trial during the last persecution. That motion was denied. There had been a preservation order for phones of Brian Albert and Brian Higgins. And as soon as they were tipped off that the preservation order was denied, or the preservation order was going to be granted the next day, or something such as like that, that's when he drove through a military base, coincidentally, and cracked his SIM card in half, threw his phone away, and got a whole new phone, because he had a whole story about that too. He had a whole story about that because one of his confidential informants or something somehow got hold of his cell phone number, and so he had to get a whole new number. But before he destroyed his cell phone on that military base, he went to the FBI headquarters, and his friend Matt Kelch helped him use the kiosk there, and he selectively cherry-picked and downloaded a whole bunch of text messages between himself and Karen Reed, and then he brought them all in, printed up nicely in a packet, and brought them in with him when he went to give his statement to the Massachusetts State Police. Melanie, you missed it. How did they have videos from 1/1/22 if all video was lost after 30 days? Yeah, if it was all overwritten. Well, I think it was a click and drag to the defense. Great point. Great point. Again, they're going to need to explain themselves, right? All of it was overwritten after 30 days. That is a great point. Both pages. I can't explain it to you. Maybe the judge will ask that question of the attorney during this next hearing, or during the evidentiary hearing. On January 28th of 2025, just a few short weeks ago, the Commonwealth provided the defense with surveillance video from the main driveway side exterior Sallyport that depicts a different camera angle of the defendant's vehicle arriving at the Canton Police Station Sallyport. I mean, what are the odds? Notably, consistent with other videos received from the Canton Police Station Sallyport, the quality of video is poor. Yes, because we used the same person to alter this video as all the other videos that we already gave you, throughout time in dribs and drabs. There's absolutely nothing depicted in this video that is exculpatory or undermines the consistent evidence that the defendant's right rear taillight was broken and pieces were missing prior to the vehicle being towed from Dighton. Oh, you know what you don't have? Photos of the taillight in Karen's parents' driveway in Dighton. You don't have that. We know Michael Proctor had his cell phone in his hand. So even if he didn't have a camera, he certainly had a cell phone with a camera on it. He was able to text a lot. And also, as we read in the defense motion, this video, which is so poor, shows the rear of the vehicle, but coincidentally, the right rear taillight is blurred out. I mean, what are the odds? What are the odds on that? Ray Space says Higgins destroyed his phone on September 29th and got the order on September 30th or something. Yes, I remember that. Yep. Remember. I don't know. You think Higgins is in WITSEC? Where do you think they would send him that nobody would know who he is? Idaho? Anybody here from Idaho? Would you recognize Brian Higgins in a two-man lineup? I don't know that there's anywhere he could go. Prior to late January of 2025, the prosecutors had never seen this video. Okay, well, build a shield around yourselves, guys. Build a shield around yourselves because somebody's maybe going to jail for tampering with evidence. But, it wasn't me. After directing a review of all physical and data files, this video was located within a paper case file of investigators. Oh, so now the video was in a paper case file? Wait a minute. I thought it was on a hard drive of a retired detective. And then before that, it was in an iCloud account of a retired detective. But now you found it in a paper file. The story keeps changing. It keeps morphing. I don't even know what it'll be by the time they get to argue this in court. Yeah, in what format? Exactly, in what format? He acts like this is normal. Says Bridget. Look the other way, Clerk Jim Clown says. After inquiry, it was learned that an investigator obtained this video from the Canton Police Department in 2022, and it was placed in a physical case file. Am I losing my ever-loving mind? Now it was placed in a physical case file. Anyone? And never provides the prosecutor or multimedia assistant for download. Well, you know what this is? This now has become the Baldwin case. The only thing that would make it closer to the Baldwin case is if it was placed in a physical case file with a different case file number on it. Oh, that is so good. Maya is in Utah, and I sure could pick him out. I don't think there would be any place safe for him to be put in witness protection at this point. Yep, that's Baldwin, Mystery and Eddie. Oh, Mystery and Eddie. I like it. I wonder how they're going to report on this today over there at WBZ and Boston 25 and, Court TV. And thank you, Michael. Melanie, the story did change that the video was on a hard drive detective storage file and was at the Canton PD. Bev should have immediately given Karen Reed the reimbursement of their expert right. She denied it because now it was in a paper file. But actually, no, because this one wasn't even turned over until January of 2025. And their expert went there in December of 2024. It keeps changing. The story keeps changing. Higgins is probably in Massapequa Park. Couldn't find Huerman. Police had his description. Thanks, Maria. That's great. Tying the two cases together. Oh, okay. There's a new motion out. Yeah, okay. Whatever's coming, we're gonna have it. Don't worry. We're it's all coming into the inbox as we sit here. So don't worry. Although the prosecutor was wholly unaware of this video until recently, Commonwealth does not dispute that the video was in its custody during the defendant's first trial. Had the prosecutor known about this video, it would have been produced as every other video known to the prosecutor was. Wow. I mean, wow. Does that argument hold any water at all? Or is it like a colander? Even in circumstances where the prosecutor fails to disclose evidence a defendant is entitled to receive, there must be a showing of irremediable harm to the defendant. Yeah, like that first trial. Like that. This court must examine the extent to which the defendant was disadvantaged in defending herself when considering the prejudicial quality of exculpatory material evidence. Quote, in measuring prejudice, it is the consequences of the delay that matter, not the likely impact of the non-disclosed evidence. Really? And we asked whether the prosecution's disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting his case. Yeah. For the first trial. Because now she's subjected to a second trial. Do you see how that works? And I would love to, wonder if Commonwealth v. Rodriguez was a retrial or an original trial. Because this doesn't happen out there in other jurisdictions in the real world, except maybe in the courtroom of Judge Gull, who is right now, Judge Canoni is like, hold my beer, Judge Gull. This doesn't, I just can't. I just can't. There's a couple of prosecutors out there on the cesspool of Twitter who thinks, the defense did so many horrible things last week by not disclosing that they paid an invoice, that they were drop mailed from ARCA after the trial. And I don't know how they're going to defend this if they're ethical prosecutors. I don't know. Can't wait to hear it. And then they go on to boldly state the defendant cannot show irremediable harm to a right to a fair trial as it relates to the Canton Police Department surveillance video. Except that it shows her vehicle being backed into the Canton Sallyport and shows a view, not a clear view because it's blurred out, of her taillight. Okay. While the January 28th, 2025 production was untimely, I don't know, you think? Almost 3 years to the day of the murder of John O'Keefe, Boston police officer, fellow brother in blue. The poor quality of the video makes it difficult for either party to benefit from it. Furthermore, this video depicts the same event that was contained on the surveillance videos produced on April 4th, 2024 and April 23rd, 2024, simply just from a different camera angle. Wow. Simply just from a different camera angle, just like it was simply inverted mirror view. Same thing, just simply from another camera angle. Further, while the Commonwealth would argue that the videos from the Canton Police Station Sallyport are inculpatory, the defendant benefited during the first trial by suggesting, without any substantive evidence, that the poor quality of the video and or gaps in the time due to an improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. Well, I mean, what he's saying here is Karen Reed should really count her blessings. She really should count her blessings because not only was she wrongfully persecuted the first time and then subjected to a hung jury when she was really acquitted of 2 charges that the court never even asked about, and now is, subjected to double jeopardy by having to be re-persecuted. The defendant benefited during the first trial, really? Do you think there's anything beneficial about an innocent woman being persecuted for murder when John O'Keefe was not hit by a car and a car did not hit John O'Keefe? Do you think there's anything beneficial about that? About losing your job, having to sell your home, being over $5 million in debt in legal fees, having to go through all of this again for the last 3 years, being arrested twice, cashing in your retirement accounts? Do you really think that's beneficial to a defendant in your county? I can't, Olivia, I can barely breathe. I can't believe this BS, Melanie, says Olivia. Can't handle this gaslighting anymore. Where are the adults, the good people? Where's the freaking judge? This is unbelievable. Right, that girl, T. I hope this is worth it for him. He's absolutely making a fool of himself. The defendant benefited. She benefited. It was good for her that we turned over such piss poor quality video. It was really good for her. It was fantastic. I'm noticing that StreamYard is glitching, so if I go off, I'll come right back, as always. She benefited from it. I don't know how they sleep at night, Swiss Miss. I really don't. In November 2024, the defense made an informal discovery request relative to Canton Police Department videos. The Commonwealth and Canton Police Department facilitated the request. And on December 12th of 2024, in the presence of the defendant's expert, it was discovered nearly 3 years after the incident that the footage on the DVR was overwritten. Oh. And the system is no longer maintained the original surveillance footage to be forensically extracted. But you still have it and you took it off within 30 days, maybe, or not, or you saved it and then you at some point destroyed it because you knew that it was exculpatory and there's no metadata, so nobody can tell. You should all be afraid. You should all be very, very, very afraid because Karen Reed could be your daughter, your sister, your wife, or you or me. And this is the fact that this officer of the court is putting this on paper in good faith, allegedly, is mind-blowing. This also marked the first time the defense had made any request for metadata or logs pertaining to these videos. as neither the defense's February 2nd, 2022, nor October 5th of 2022 motions or corresponding orders makes any reference to such materials. You know why? Because it's ducking obvious. You don't need to specifically ask for an order to preserve metadata, you dumb ducking jackhole. Really? You're now saying in front of the world that because they didn't ask for the video to be preserved with the metadata that you weren't required to? Really? Olivia I'm pounding on a keyboard right now somewhere. If you don't subscribe to Olivia on Twitter, I don't play in the cesspool of Twitter. But she's at Olivia Lambo on Twitter. I believe it is Olivia Lambo, right? At Olivia Lambo, Lambo. She ties it all together in a way that not many can. Now they're going to quote some case law that they think helps them, and they're going to say, a defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the lost or destroyed evidence would have produced evidence. I'm sorry. I just got another habeas filing. All right, hold on. There's so many things popping at once that just, settle in because we're going to be here for a long time. Me be here a long time with you. You know where that comes from. Back to the fertile imagination, that access to the lost or destroyed evidence would have produced evidence favorable to his cause. If he meets his initial burden, a balancing test is employed to determine the appropriateness and extent of remedial action. The courts must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Well, I submit to you that all three of those factors, if you were to weigh them, they would go like this in favor of the defendant. But, that's just me and my, fake law degree. Because the Twidiots don't seem to think that I'm actually a lawyer. Here, the defendant fails to meet her initial burden. She has presented absolutely no evidence that a forensic copy of the Sallyport surveillance video with metadata and logs would have been exculpatory. Rather, she relies upon innuendos and unsubstantiated allegations that are speculative at best and not the equivalent of concrete evidence, according to Commonwealth v. Dinkins and Commonwealth v. Key. Even if this court were to engage in a balancing test, because we don't even think you should engage in the balancing test, Judge. Even if this court were to engage in a balancing test, dismissal would be inappropriate, as there is no evidence of egregious misconduct on the part of the Commonwealth, and any potential prejudice stemming from the overwritten videos could be remedied at trial. Really? The defendant can point to no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor quality video. An inability to obtain a forensically extracted copy of the surveillance video to fully disprove the defense's repeated and baseless allegations of evidence tampering. Oh, sir, are you ruining the day that you ever decided to come on to this case at $250 an hour? Are you? Before we move on to the statement of Jennifer McCabe, I need to go to the chat for a minute and see how you guys are doing, because I can't. The Commonwealth is equally aggrieved by the poor video quality. But I'm sorry, sir, didn't you just say that you think that wellness check video shows a shattered taillight? And didn't you also say some other things that I pointed out that are completely untrue? And you're saying that the Commonwealth, it's not fair to the Commonwealth because the poor video quality, even though we turned it over late and we never even knew we had it and nobody knew, and implausible deniability, and they didn't give it to us, and it was in a cloud and then a hard drive and now a paper file. I would not call these allegations of evidence tampering baseless, because if you had the metadata, you could show the evidence was not tampered with. Whose burden is it to prove this case, Mr. Brennan? You may have forgotten, but you are now the Commonwealth, and you have the burden to prove this case. Karen Read does not need to prove her innocence, sir. I know that everything's inverted in Norfolk County, where you come from, and that's the way that you do things in Massachusetts. But out here in the United States of America, the burden of proof is on the Commonwealth to prove beyond a reasonable doubt that Karen Read hit John O'Keefe with her car. You can't do it. But we really need to make sure that the Commonwealth gets a fair trial here. Before we go to the statement of Jennifer McCabe. Sonia, thank you for your super chat. And she's from Croatia. The world is watching. Massive crazy Weeman. Thank you. It says, oh, I see this all the time when the prosecutor's trying to get someone to plea in the UK, but it's crazier in this case. On top, thank you so much for your super sticker. Thank you for having coughing with you. Thank you. I turned over a whole lot less for your super chat. I turned over a lot less. We were duped, says, can't wait to see who argues this for Karen Read's team. Thank you for your super chat. Friday just got better. Can't wait for my merch, says Cat's Meow. Oh my God. And she gifted 5 memberships. Yay, Cat's Meow. And to those 5 who were gifted, thank you so very much. Cat's Meow. Welcome. Nina, I'm seriously concerned about the metadata issue. It wouldn't be surprising if they create AI generated videos and Bev allows it. That's so scary. Well, you know what they've done on the cesspool of Twitter? They've created some AI videos to make it look like Alan Jackson and Karen Read were huggy, kissy, gropey, and some idiot, whoever made it, left the CapCut logo on at the end of the video. So that was clearly done. And yeah, I mean, at this point, would you put it past them? Metadata is a million times more important now that there is AI. I would agree with you. Lamasu says Canton PD is the crime scene. That's where they shattered Karen's taillight to frame Karen Read. Yeah, I think that's what we're talking about. Thanks, Suze. Witch in the Wardrobe is here and says, see, Canton PD recused, but they brought the car in anyway. Yeah, even though there were many MSP barracks along the way. But, you know, they said they had to go to Canton PD at Sallyport because it was heated. That's what they said. Lilith, wouldn't Karen's car be considered the scene since it's supposedly the means of death? Well, it's absolutely the murder weapon. But there's been a lot of controversy about that. Thank you for your super chat. Keely Burke, welcome. Kelly Kell, how long have they worked in the Norfolk office? Pull previous cases these specific prosecutors worked on and compare the discovery. I'm going to lose it. Yeah, so is every defendant who's sitting in prison right now because of being convicted by these guys. So yeah, they're going to lose it too. Thanks for your super chat. More of a Leslie, too bad. If the Canton PD had honored the ordered recusal, they wouldn't have to worry about those cameras in the Sallyport. Oh yeah, good point. Thanks for your super chat. Fox's sake, what can be done about this? Can the defense counter this motion, or does it have to be argued orally? Well, they may need to I don't know if they get a chance to reply, but it's going to be argued orally. And as you know, you can just bring up, you know, all kinds of stuff that you didn't put in papers when you orally argue, because especially if you're Hank Brennan, you can go on for a half an hour and just say, oh, I don't have any opposition. I just want to share some thoughts with the court, and she'll consider it. So, first rule of holes seems to apply. Thank you, Roy Handy. Matt McCabe has a family with many of the last name McCabe. Thank you, Mindless Grift Cult Magnolia Gypsy. Yep, that has been rehomed. Thank you. Where is she copying from? It's now April of 2024. Well, after the 30 days from January. That's a great point, Mudrocker. And that's why these people are going to have to be called in to testify, I think. They sent a raven. That's a great one. Zeke, thank you. Bobby Alessi's Butter. How can and should the defense rebut this nonsense? Well, they're going to get a chance to. An oral argument. They've made a motion to extend the time. The Commonwealth has just opposed it and says they're ready to go. They're ready to go on Tuesday. They want to go, go, go. We'll see what happens. We're going to cover that motion after this one. Yes, Melanie, this is some very serious ducking. Yes, thanks, Lori Lake. Carrier Pigeon says, Tracy, that got lost in the snow. Thank you, Lilith. Thank you. They did it by text and the phones are rehomed. Of course they are. But of course, Piney Woods is here. We're so ducking far through the looking glass. I can barely stand it. Love you in the chat. And I'm fighting for Karen Read. Thank you. Hot Water Boy. Oh, you guys are so amazing how you change your names in midstream to go along with something I say or something that you hear in chat. Hot Water Boy says, I've been watching this since day one and I cannot believe this is even for real. It's like a bad movie. It's like I can't even believe this has been renewed for season 2 because the first season was so unbelievable. Fire on Acid says, what would happen if AJ or David Yannetti couldn't take it and they just kind of went off on Bev? Sanctions? I couldn't keep my cool this long. I know it's hard. It's hard. I'm glad I'm not sitting in the courtroom because it would be hard for me to keep my mouth shut in the audience, I think. Abacus Flinch, hey, Brina, maybe you can ask the defense for the metadata of the corrected video. Oh, thank you for your super chat. 20th Century Fox, I'm so annoyed that Brennan's so-called legal assistant doesn't double space between sentences. It's all squash, much like the Commonwealth's case. Well done. The hammer was on standby, says, I turned over a lot less. Thank you. Rainy day. Another gut feeling. Higgins and Berkowitz broke the taillight, not Proctor. Unknown DNA from one of them. Proctor looked the other way. Thanks for your thoughts. Bodie Labs was not provided with Urey and Proctor's DNA profiles. Oh, that's interesting. Those were held only by the Massachusetts Crime Lab. No one was excluded from John's blood samples. Great point. Thank you, Suze, for pointing that out. Thrift with joy. How does the prosecutor know that poor was the condition it was recorded in if the original video and metadata don't exist? Thank you so much. Thank you so much for saying exactly what I'm thinking. Decline, hanky spanky, so many lies. Wow, just wow. Thanks for your 10, Decline. Homegrown Alligator is here and watching from Australia. Free Karen Reed and justice for John O'Keefe. Melissa's been here for 6 months and says, hey, Melanie, Maz in chat. Can't imagine the rot that's going to be in this response. Well, we're not even done with it yet. Mudrucker, how did January 1, 2022 video exist in August 2024 if it overwrites every 30 days? Yep, great point. Jessica, wasn't Brian Higgins drinking as well? Yes, he was. Jameson and Ginger. Again, I ask, where is the video of Karen Reed's car backing up? Thank you, cat artist. I don't know. Christine is thanking me. Thank you, says Free Karen Reed. Thank you. Michelle, I'm late to get on the crazy train. Sounds like Commonwealth is up to shenanigans again. See no evil, hear no evil, say no evil. Thank you on top. Thank you on top again. Decorated dudes trial. Greg says, I've been saying it for weeks. They're all definitely pointing the finger at Higgins this time. You're not the only one. Hank lies about the entire time for CERT team time, says Kelly. Thank you. Al dente, another Canton cop drunk while performing duties. Did Higgins get paid for moving those vehicles? Did he log it? Nobody knows. Only the shadow knows. Cubert's here. At this point, I think Pac-Man, Frogger, and Donkey Kong and Super Mario need to join us for this mess here in Canton, Norfolk County, and Massachusetts. Thank you. Thank you, Cubert. Lotsy's mom, is there any way Bev can deny an evidentiary hearing on this? Well, she's a gatekeeper, so, she can pretty much do whatever the duck she wants. I don't even know at this point. I don't even know. She could. Buzzing for truth, the man that can text but can't take a picture. Yep. Kelly, O'Hare testified 4:55. First O'Hare at 5 p.m. The rest of the team arrived 5:21, 5:24, 5:34, 5:41. Tully came shortly after to tell them what to look for. Thank you. Thanks, Kelly, for looking that up. Abacus, I bet you Kevin from South Boston could pick Higgins out of a lineup. You wrong. Larry Knockcroft, my dad used to tell me, if you have to talk yourself into something or inverted out of something, you already know the answer. What does this sound like? Thanks for the 10. Cat's meow, is this real? I feel like we're being punked. How does this even happen? Ashton Kutcher is going to jump out of the corner of the courtroom one day. And I'll allow it. Thanks for the 10. This is infuriating for Fox's sake. Gaslighting at the max. Any cases around that time that did save the footage? Great question, Sharon. Dennis the Menace, Bohemian Rhapsody gibberish, Miss Miller. Thank you, Melissa. Wouldn't new video of backing into the Sallyport potentially change all vehicle data, including key cycles used as evidence in 1.0? Yes, thank you so very much. We've discussed that before, but it can never be discussed enough. Deborah, how would Hank fight this if Karen was his client? Good thing I'm not babysitting my granddaughter today. She'd have a new vocabulary. Thank you. All right, moving back to the document. Let's talk about the statement of Jennifer McCabe and what the Commonwealth has to say about that. Hold on. Statement of Jennifer McCabe. In violation of the defense's discovery order to produce all reciprocal discovery, including impeachment evidence, to the Commonwealth prior to the start of trial, it was during the third week of trial, on May 7th of 2024, that the defense produced reciprocal discovery to the Commonwealth regarding location information of Jennifer McCabe's cell phone. Didn't the Commonwealth already have all of that information already? I thought they did. 3 days later, on May 10th, 2024, in anticipation of her trial testimony, the Commonwealth met with Jennifer McCabe, as it does with all its witnesses. Well, you know who met with her? Tully. Not the Commonwealth, not ADA Lally or McLaughlin or an attorney to prep her for her testimony. She met with Tully. And she told Tully what she wanted to look at. Hey, Tully, let me hear my 911 call. Hey, Tully, let me see the dash cam video of me and Matt. And she said Matt was with her when she went there on May 10th. But on the stand, didn't she say she was with Allie McCabe? Did anybody go back and watch that? On May 29th, 2024, Lieutenant Tully wrote a police report. Oh, okay. So on May 10th, he met with them and then he wrote the police report. It's not a police report. Is it a police report? It's like a statement. Memorializing the meeting, and explained when asked why her cell phone would have been in the area of the residence of Sergeant Michael Lenk on January 30th of 2022. Quote, Jennifer stated she was with Carrie Roberts, who was picking up her daughter at the residence, right? But she testified on the stand that she was dropping off her daughter. Jennifer did not speak with Michael Lenk while at the residence. See Defense Exhibit P. We looked at that yesterday. The Commonwealth produced Lieutenant Tully's report on Monday, June 3rd, 2024. Anybody know the date of testimony? The date of Jennifer McCabe's, the first day of her testimony, but it's definitely before June 3rd, I think, of 2024, right? Footnote 3. At the request of the defense, the trial was suspended on Wednesday, May 29th of 2024, Thursday, May 30th, 2024, and Friday, May 31st of 2024. I'm sorry. So that's when he decided to write down the events that occurred on May 10th, on May 29th, because he had a day off. What does that have to do with anything? Just another MSP guy throwing away his life, his career, his pension. I'm sorry. Yeah, apparently they dropped off a child at Lenk's house and never picked her up. Maybe she's still there, says Cusco Wright. Pebble says these people are disgusting. On June 18th, 2024, in response to the same claim raised by the defense, the prosecutor explained to the court that, quote, Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying. Oh, wow. So after Jennifer McCabe testified, so she couldn't be questioned about it, but we gave it to you before Tully testified, so no big whoop. No biggie. No big whoop. No biggie. She did more than look at some video. She listened to her 911 call. You gave her a transcript of her grand jury testimony. Her husband, Matt, was there too. And so it was also after Matt's testimony, probably after Allie's testimony. This is insane. A single question? Why would your location data show you at Michael Lang's house? And no follow-up questions after that? Okay. Were there any statements made after that? Maybe he asked her one question, but what did he tell her after that? What were the statements made to her? You're going to need to clean that up. You're going to need to figure out how to explain it. They're going to try and impeach you with it. You better come up with a story, and you better make sure Carrie Roberts is on board. Right? On May 21st, 2024, Attorney Jackson vigorously cross-examined Mrs. McCabe. Oh, yes. So, oh, yes. Okay. So that's when the cross was, May 21. He didn't even draft the report. He met with her, Tully met with her on May 10th. May 24th, she's cross-examined vigorously. On May 29th, he writes the report, and then they turn it over on June 3rd. You don't think there's anything wrong with that, do you? On May 21st, 2024, Attorney Alan Jackson vigorously cross-examined Mrs. McCabe. Now she's Mrs. McCabe, not Jen, not Jennifer. She's Mrs. McCabe. And she detailed her reasons for being in the driveway of Sergeant Lank's home on January 30th of 2022. Now she's in the driveway. Did they always say that she was in the driveway? I don't know. I kind of thought they were parked on the street. Were they in the driveway? Did they ever say driveway? Now she's in the driveway. During cross-examination, Attorney Jackson elicited testimony that it was Lieutenant Tully who asked Mrs. McCabe an open-ended question of, did you go to Michael Lank's on January 30th? That's not really an open-ended question. That's a question that requires a yes or no. Does anybody know the difference between a direct question and an open-ended question? Anyone? Bueller? Anyone? Attorney Jackson then questioned Mrs. McCabe about whether there were any follow-up questions or whether the Commonwealth revealed the defense's report. Mrs. McCabe testified that neither occurred. Revealed the defense's report of what? Of her location data? Well, they didn't have to. All they needed to do was ask her that one question. Mrs. McCabe testified that neither occurred. See Defense Exhibit O. Notably, the Commonwealth produced Lieutenant Tully's report once it was available, because, you know, typing is really hard. To the defense prior to Lieutenant Tully's testimony. Lieutenant Tully was available to be cross-examined about his recent meeting with Jennifer McCabe and or any perceived inadequacies in the investigation related to Mrs. McCabe's phone's whereabouts. The defense declined to do so. Oh, Mrs. McCabe's phone's whereabouts. So now are you going to claim her phone was there, but she wasn't? Did she leave her phone in the car, in the driveway, and then bring her body into the house? This was really cold that day. Do you think she really sat in the car in the driveway for the 45 minutes that she may or may not have been in the driveway? Again, it's the defense's fault. Furthermore, on May 22nd, 2024, Carrie Roberts testified. Mrs. McCabe had testified one day prior that she had accompanied Carrie Roberts to Sergeant Lank's driveway. Oh, to his driveway. Now it's just the driveway, not his house. He's very careful not to say his house, just driveway. The defense relinquished their opportunity to cross-examine Mrs. Roberts about the event at Sergeant Lank's house, let alone ask her, one of only a few percipient witnesses, a single question. It's their fault, Your Honor. They didn't cross her. Even though they didn't have this report, they didn't cross her. It's their fault. That reminds me of The Handmaid's Tale. Anybody watch The Handmaid's Tale? Aunt Lydia said, whose fault is it? And all the handmaids pointed to, I forget the character, but I know who plays her. Your fault, your fault, your fault, your fault, or her fault, her fault, her fault. This is very Handmaid's Tale-esque. Olivia says, if these investigators didn't even know this location information for Jen McCabe, how can we trust any of their investigation? They literally investigated nothing. That's right. However, most enlightening on the defendant's lack of prejudice is that on June 18th, 2024, this is enlightening on the defendant's lack of prejudice. Buckle up, buttercups. Attorney Jackson stated, quote, during trial, they, the Commonwealth, interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they, the Commonwealth, held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony. See Exhibit O. Immediately after, the court offered, do you need to call her again? Attorney Jackson responded, oh, yes, he did, because I remember this well. No, Your Honor, I'm not That's not, and I think the court understands that's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. The court, I'm sorry, I missed that. You're what? And when I went back and watched that, he was pretty loud. Like, he could clearly be heard. It wasn't like he forgot where the mic was. That was completely sarcastic by the judge. I was like, I'm sorry, I missed that. Like, daring him to say it again. And he said it again. I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. Right? What, didn't you take that as a dare? I'm sorry, I missed that. You're what? Okay, all of this stuff about the phone being downstairs, her watch is upstairs. I don't have any like concrete evidence of that. I know somebody did a video on it, but I'm not gonna like, let's not sidetrack this because I don't have any personal knowledge of that creator. I don't know that creator. I don't know how accurate that video is. I don't know anything about that video. So if we could just try not to derail the chat about that alleged information about the Google search and Matt McCabe and all kinds of other theories. We like to stick to the facts here if we could. Thank you so much. Appreciate you guys. When given the opportunity, the defense declined to do so. Okay. Next, trial court security juror dismissal. Oh, great. I can't wait to see how they spin this about Trooper Fanning being in charge of the jury. The jury tampering, alleged jury tampering. I would not suggest to anyone to file any notice of judicial misconduct. It would be illegal, improper, and unethical for me to suggest that to anyone. And I also would appreciate if people did not put that in my chat or my comments. It's not something that I could talk about or ethically permit everyone to encourage everyone to do. I just wouldn't. Okay. And again, thank you, Bex. But again, redirecting my stream to someone else's channel is not appreciated either. Thank you. Thank you so very much. Appreciate it. The defendant's claim that a lieutenant of the Massachusetts State Police was in charge of jury security is patently false. At no time did Lieutenant John Fanning have contact with, nor control or influence over the trial jury, nor was there, quote, jury tampering that deprived Ms. Reed of her constitutional right to a fair trial. Defense motion at 3-4. The defense's brazen misrepresentation, previously proffered in media interviews, in direct violation of the impoundment order of juror discussions and sidebars, solely to mislead the public and jeopardize the integrity of the judicial proceedings, are false and dishonest misrepresentation. Oh, hey, pot, meet kettle. Footnote number 3. On February 17th of 2025, Boston 25 News aired an interview with the defendant and Attorney Jackson, where Attorney Jackson stated that Lieutenant Fanning was the very person governing the jury. Attorney Jackson also stated, I don't think that he ever named Fanning, did he? I don't think he did in that interview, because we've watched that interview together. And I think he said that there was someone who was in charge of the jury. I don't think he named him, right? No, he didn't name him. So again, another misrepresentation to the court. Yeah, they named Fanning. Okay, I'm going to read that again because this is what Brennan puts in his footnote 3. He says, Attorney Jackson stated in this interview that Lieutenant Fanning was the very person governing the jury. No, he did not say that. He said someone close to the investigation was in charge of the jury. That's a lie. You wrong. But who cares? Because you're just the prosecutor. Nobody cares if you lie. Attorney Jackson also stated, despite representations in this court filing, that he had, quote, no specific evidence of jury tampering. Here's the YouTube link to the audio and video of the interview. Oh my. No, he didn't name anyone, right? I'm not throwing shade at anyone, Yuri's math teacher. Thank you, though, without watching the video. I don't need people in my chat redirecting other people to watch other stuff while they're in my chat. If you don't like it, then sorry, I'm not throwing shade on anyone. I don't know this creator. I've not watched this creator's content. I don't know what this creator's background is. So again, if you're out of here, bye. Bye-bye. Bye-bye. Sorry, I don't know what to tell you. I'm not even naming the person because I don't even know who the person is. Wow. How can I opine on something that I haven't watched and a person that created that I don't know and I don't know their background? I don't know anything about them. And you're going to just chatter about it and tell people to go watch it. I have no, like, that's beyond. It's beyond. And you're out of here? Okay. Go. It's not an airport. You don't need to announce your departure. It's like ridiculous. Take a deep breath. Everybody. The executive branch of government is separate and distinct from the judiciary. The governance of the jury is solely within the power of the trial court and sworn court officers. Okay. The defendant's first trial raised significant safety concerns for both parties. Oh, we're going to blame it on safety concerns now. Members of the victim's family, witnesses, court staff, media, and the public. To effectuate both the defendant and Commonwealth's rights to a fair trial, this court ordered a buffer zone around the courthouse. To enforce the buffer zone and maintain order, approximately 50 uniformed officers from the Massachusetts State Police and other local departments were deployed each day on foot, motorcycle, and bike in the area directly surrounding the courthouse. Additional law enforcement resources were available in proximity to the courthouse at the Dedham Police Station. As a superior officer, well, that's debatable, assigned to the Norfolk District Attorney's Detective Unit and the only supervisor who was not a trial witness, Lieutenant Fanning was one of the commanding officers who was involved in the safety and peacekeeping efforts occurring outside the courthouse. Well, again, you're naming him in your papers. The defense did not name him in their papers. And if they did, wasn't it redacted? Wasn't it redacted? Yet somehow the defense conflates that fact to misrepresent that Lieutenant Fanning therefore improperly influenced and tampered with the jury. Well, I don't know. I've been saying all along, I think maybe one of the jurors, at least one, may have gone to the feds. We'll see. To do so, the defense omits the remainder of District Attorney McLaughlin's statement to the court. ADA McLaughlin stated, I guess this was at a sidebar, because they're not even saying. She stated this when. However, conveniently omitted from the defense's filing and extrajudicial statements is the following from ADA McLaughlin. Again, details are important. When did she say this? And then that's redacted. Something right before it is redacted. Defendant's Exhibit S. At no time did Lieutenant Fanning enter the Norfolk Superior Courthouse during the defendant's trial. Oh, he never entered the courthouse? Did he go on the jury bus though? At no time. Okay, you know what's going to be great? If anybody's got a video of Fanning entering the courthouse that can disprove this. No, I didn't say a juror went to the feds. I said, I've been thinking about that. I've been thinking about maybe a juror who was kicked off may have gone to the feds. And, you know, could this be jury tampering, make it a federal crime? If so, good. Moreover, he never saw, let alone spoke to any member of the jury. Well, how do you know that? How do you know that? Because you didn't speak to any members of the jury. In fact, you wouldn't even speak to the members of the jury who emailed you because you told them you could not keep their information confidential. Furthermore, there is absolutely no evidence that the dismissal of the juror was improper. Yeah, there was one woman who was dismissed prior to deliberations who was very upset about it. And She was apparently obviously pro Karen Reed based on her facial expressions during the course of the testimony. And he's just stating this, but then there's a whole bunch redacted. So I don't know what he says after this. But again, I don't know when McLaughlin's statement was. Probably wasn't, it was obviously on the sidebar, but we don't know when. Because details are not important. Facts are not important. That's why when people start putting stuff in the chat about some other creator's video and stating it as fact, that's why I have a problem with that, because I'm a legal-based channel and I work on facts here and court documents and testimony and police reports, not speculation of a creator. And you guys come in here and state it as facts. I don't care if it's pro Karen Reed or not. Sorry if I have integrity, and that's the way I run my channel. Again, it's not an airport. The defendant, and I'm not even going to apologize about it. The defendant's preposterous claim, one that Attorney Jackson has stated he has no specific evidence of, should be rejected outright. Conclusion: in sum, the defendant's motion should be denied. The defendant can show no irremediable, is that even a word? Irremediable prejudice to her right to a fair trial, nor has the evidence in good faith shown that the Commonwealth engaged in prosecutorial misconduct. Oh. See, on Committee for Public Counsel Services versus the Attorney General, presumptive prejudice warrants dismissal to prevent repetition of this conduct. Dismissal of the case is accordingly not appropriate. Further, where the defense's claims do not raise any substantial issues, nothing is substantial. You know what's not substantial? Your evidence against her. The request for an evidentiary hearing should be denied. XOXO, Michael Marcy, by Hank Greenan, Adam Lally, Laura McLaughlin, soon to be witnesses. All of them, in my opinion. And then there's supposed to be an affidavit with this. Hang on. Where is it? I thought it was attached. Help, please. Hank is such a liar. Let's go to the chat. For the love of sanity, every one of us cupcakes, please, will the universe and someone send someone to stop this farcical madness. Well done, Irish Wolfhound Mama. Pauline says, please send Spanky back to band camp. Julia's thanking Hank for disassociating her from her migraine. Scott says the Canton PD was and is an accredited police department. I sent you the standards for how a police department is accredited in Massachusetts. Canton PD has zero excuse for no crime scene. Well, that's great. We can go over that. Maybe not today, maybe another time. Because my credulity is becoming exhausted. Laura, thanks for the 5. Is there a reason the defense didn't file the entire motion to dismiss earlier? They've had most of this information for a while, right? Well, because their time to turn over their discovery didn't start, and they still are receiving evidence from the Commonwealth. So it made more sense to wait to see what else would magically reveal itself. Football fan, thanks for the 5. They had to wait until the Commonwealth said that they were done turning over the evidence, you see. But then even after they filed their certificate of compliance, they still kept turning stuff over. So it was like a ghostly certificate of compliance that didn't really mean anything because they weren't really done. Judge Bev's abrupt, lengthy recesses and tremors are a new phenomenon. Do you think she's meeting with her attorney, Marcy? I can't speculate. But thanks for your super chat. Nothing to see here. The lies Hank tells. Thank you for being here. Thank you for your super chat. No shrinking violet. Karen's team should call a straight cop to the stand to testify how an investigation should be done. I don't know if they're going to be calling a police procedures expert, but it's a thought. Thanks, Kat Q, for tuning in from Canada and for your super chat, super sticker. Cindy, unfortunately, I think all of us here in chat know more about this case than Brennan. I know I don't accept jobs without doing research, so what the duck, Hank? Thanks, Patty. Please subscribe. Let's get to 100K. We want that silver button. Thank you, Fern. Attorney wannabe. Possibility the huge redacted areas on the motion are related to the nephew's testimony prep regarding the steak tips. I think it had more. I don't remember exactly where in the section was, and without pulling up the defense motion again, I mean, anything's possible, but I don't remember exactly where that fell in the order of things. So I cannot opine as to that right now, but thanks for your 10. Emma is here from Ireland, sadly resigned to the fact that Bev is the biggest obstacle to John and Karen getting justice. Brennan's looking at this through pink sunglasses. Thank you, Dennis. On top says, I'm checking myself and Higgy into B Ford when this is over, and Betty Ford. Thank you, Attorney Wannabe, for gifting a membership. LC, thanks for the 5. If Bev denies the evidentiary hearing, can the defense appeal prior to trial due to prejudgment effects? I don't think so. I don't think so. I don't 100% know the rules of interlocutory appeals in Massachusetts, and I don't want to give you the wrong answer, but it's a great question. Let's be real, 72. Thank you for becoming a member. Buzzing for truth. This is outrageous. We are outraged. Does anyone else remember Carrie testifying that the taillight was only cracked? Yes, I think she did. Or is my memory exhausted? Thank you, Lady Righteous Indignation. Oh, thank you so much, Desert Quill, for your 5 and your new nickname. Sarah Witherow, thanks for becoming a member. And also Grandma Law Nerd became a member. Welcome. The Misadventurous Book Mouse, protecting Lieutenant Fanning. He knows, he knows. Sandy B. Hank is so Eddie Haskell, lying with a straight face and blaming Beaver Higgy. Well done. Hank is so full of it, his eyes are turning brown, says Dennis. Another 3 blind mice motion, says Hank's specters speculation. Tammy Tebow says, I don't understand this trial anymore. Where is all the evidence that Karen hit him with her vehicle? If they don't have it, this case should be over. Should be over, she says. Who knows? I'm going to go back to, because I know that I have his affidavit somewhere, so just give me a second to find it. Do 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 do. I thought it all right. Hold on. 526 and 527. Or is this the one that had them both? Here it is. Okay, found it. Never fear. Because Hank Brennan did submit an affidavit. But really, in my opinion, should have been from Lally. Because Lally knows the facts of that video and where it was and who found it in the paper file. So there's that. Details don't matter. Apparently they don't. Oh, I should leave the name tag up for a second because this is the Commonwealth's affidavit in response to defendant's motion to dismiss for extraordinary governmental misconduct. My name is Hank Brennan, and I am a special assistant district attorney and the lead trial attorney for the above docketed case. I entered an appearance in October of 2024. Oh, my name is Adam Lally, and I am an assistant district attorney in Norfolk County. I have been a prosecutor assigned to the above docketed case from January 2022 through the present. My name is Laura McLaughlin, and I am an assistant district attorney in Norfolk County. I am appellate counsel appearing in the above docketed case since mid-2023 to assist trial counsel. She's the appellate counsel? Has anybody ever seen an affidavit signed by 3 different attorneys? Has anybody ever seen it done this way? Is this the way they do things in Massachusetts? 3 attorneys can sign 1 affidavit? Am I still in the... Do we have any Massachusetts barred attorneys in the chat? On June 9th of 2022, the defendant was indicted by a Norfolk grand jury for second-degree murder, manslaughter while operating under the influence, leaving the scene of personal injury or death. No, they couldn't. The 3 musketeers are here. Or the 3 blind mice. Take your pick. On April 16th of 2024, A 10-week jury trial commenced. Beverly Canone, Justice. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses to manslaughter while operating under the influence. 1, involuntary manslaughter in violation of this law, and 2, motor vehicle homicide, OUI liquor and negligence in violation of this statute. I've never seen an affidavit speaking for 3 people before like this. No, never have. Me neither, Olivia. I mean, did they not want to waste the paper? On July 1, 2024, upon finding that the jury was deadlocked, the court discharged the jury and declared a mistrial. The defendant's second trial is scheduled to begin on April 1, 2025. I have reviewed the Commonwealth response to the defendant's motion to dismiss for extraordinary governmental misconduct. The statements contained within are a fair and accurate understanding of the materials received and produced to the defense. Okay, this basically says nothing. This is so facially deficient. Fair and accurate understanding of the materials received and produced to the defense, signed under the pains and penalties of perjury. 27th of February, 2025, XOXO, Hank Breenan, Adam Lally, Laura McLaughlin, none of them signed their names. There is simply a S/ and then their names are typed in a cursive font. I'm sorry, are you kidding me? They all have the exact same signature in the exact same font. They're not even really signed because details don't matter. And why all of this extraneous detail? 1, 2, 3, 4, 5, 6 paragraphs of fluff. 1 paragraph. It's fair and accurate. It's a fair and accurate understanding. Not it's the truth. It's a fair and accurate understanding. That is, I can't even, mere words cannot express for plausible deniability how lame that is. I haven't learned cursive yet, says James Lynch. You still have to sign it. There still needs to be a signature. I don't care if anybody types it up. You still have to sign it. You've seen the pleadings by the defense. They physically sign the papers. They sign them. But no, the Commonwealth doesn't. They're above they're above all. They're above all. Next up, let's take a look at the defense motion to extend the scheduling order. I can't believe this is real. I just can't believe this is real. My entire memory is exhausted. My credulity is exhausted. Where do we go from here? That's a song. Okay. Here's the updated scheduling order as it stands now. Let's take a look at this for clarity, because I try and make things as clear as I can for you. So the updated scheduling order, this is docket number 485. This was signed on February 10th. So the upcoming dates, we just read the Commonwealth opposition to the motion to dismiss. So the motion to dismiss, according to this updated scheduling order, is supposed to be heard on March 4th and 5th of next week. The 4th is Tuesday, the 5th is Wednesday. Defense counsel needs to be in federal court the morning of the 5th. And so the judge said, you can go to federal court and we will do our hearing in the afternoon or after you're done or something like that. March 6th is supposed to be the drop dead date for all reciprocal discovery. March 7th is supposed to be the final pretrial hearing and filing of all motions in lemonade. March 18th and 19th is supposed to be the hearing on all the motions in lemonade and the final trial conference. April 1 is supposed to be the trial. That was dated February 10th of 2025 and signed by the judge. However, The defense is making a motion to amend that scheduling order, which I have for you here. And that is docket number 528 that was filed this morning. Defendant's motion to amend this court's scheduling order dated February 10th, which we both just looked at together. Both, I mean, all of us, all 8,560 of us, plus me. How are we doing on the likes? What's our ratio? We can't get ratioed here. Let's see, we got 3,700 likes, 8,500 watching, not even 50%. Nah, we could do better. We could do get better. Smash the like, or I'm going to turn off the heat or the air conditioning, depending on where you are. Okay. I don't know if your audio is staticky, you may need to refresh your browser. If my audio is staticky, I think my mods would, they know how to reach me. They would tell me. But hang on, because I have to check my messages. Talk amongst yourselves for a second. Okay. All right. Thank you, Sherilyn, for the Cash App. I appreciate you so very much. And here we go. Motion to amend this court scheduling order dated February 10th of 2025. Now comes the defendant, Karen Reed. Ms. Reed, and respectfully moves this honorable court for an amendment to this court's scheduling order dated February 10th, 2025. As grounds, therefore, the defendant states the following. 1. On February 10th, 2025, this court issued a scheduling order which sets forth that the hearing on defendant's motion to dismiss is set for either March 4th or March 5th of 2025. The defense was informed late yesterday afternoon, February 26th of 2025, by Special Assistant District Attorney Hank Brennan that the Commonwealth has additional discovery to turn over to the defense, specifically alleged chain of custody reports relating to the Sallyport video. Well, isn't that interesting? Did they magically appear? Because didn't he say in court, Your Honor, we are under no obligation to create evidence that doesn't exist. But now on the 26th, today's the 28th, the defense was informed that Hank Brennan now has additional discovery, specifically alleged chain of custody reports relating to the Sallyport videos. Yeah, you can't make it up. No, you can't. You just can't make it up. Because now the magically appeared chain of custody reports relating to the Sallyport videos has magically revealed itself and created itself. And he argued very strongly that he should not have to create things that doesn't exist. He said that they didn't exist. Yes. And even the judge, when Ms. Little was arguing the motion, the judge said to her, do you expect the Commonwealth to create something that doesn't exist? I don't know. Did they magically appear? Did they create them? Olivia says he's actually creating them now. You can't make this up. I don't know. Today, February 27th, 2025, Mr. Brennan confirmed that he expects to provide those logs by tomorrow, which is now today, February 28th morning. During this same phone call today, he further informed counsel that the Commonwealth will be producing Sallyport videos to the defense on Monday morning. Monday morning, today's Friday, meaning next Monday. They're supposed to argue the motion to dismiss on Tuesday. Didn't Hank Brennan also get up in open court and say that he cannot have telephone conversations with the defense attorneys anymore because he doesn't trust them to properly and accurately describe what happened in those telephone calls? Didn't he say that in open court? Are you guys dying laughing right now? Are you dying and laughing right now? Didn't he say that? No, there's more video, more Sallyport videos. They're not coming till Monday because, we got to do a quick click and drag. It is unclear whether the videos to be produced will be duplicative of what has already been produced or whether there will be new material. And remember that Brennan in open court says, I don't know what's in there. I haven't watched it. It's a simple click and drag. I don't know. They haven't been inventoried. I haven't watched them. I don't even know what's on those videos. What? How did we get here? How did we get here? He also did say I can't trust them to tell the truth about our conversations. So therefore I can't have any more conversations with them. He didn't put it in an email. He called you. Okay. New chain of custody reports, which the defense does not have as of the date and time of this filing, will directly impact the motion to dismiss and cause the defense to modify its motion. In light of this new information, therefore, the motion to dismiss is not yet complete. Right. They're going to need to reply. The Sallyport videos in the Commonwealth's possession that have been described as having been stored on the department's video file system. This new information will undoubtedly impact our written submissions and or oral argument. It's magically delicious. I think of that every time. Parachutes and pirouettes. These videos, according to the Commonwealth, are not expected to be turned over to the defense until March 3rd of 2025. Considering the above, the defense expects to file a supplemental addendum to our motion to dismiss. This obviously cannot be done until we receive the outstanding discovery. As such, we are requesting a continuance of the hearing on the motion to dismiss so that we can analyze the additional information, confer with our expert, and file an addendum to the motion to dismiss. The defendant respectfully requests that the hearing on the motion to dismiss be moved to some date after the production of this information, but no earlier than the week of March 17th, particularly given the number of other critical deadlines that we are working to meet next week, which include satisfying all of our reciprocal discovery obligations, filing all motions in limine, and attending 4 separate hearings in relation to this case, 3 before this court and 1 in federal court. Failure to allow Ms. Reed sufficient time to appropriately address and brief these constitutional issues with information contained in outstanding discovery on the Commonwealth that directly relate to the issues underpinning the motion to dismiss would violate her constitutional right to due process and a fair trial. Yeah, but they don't care about that. Ain't no constitutional rights in Massachusetts. XOXO. See, Elizabeth Little, there's an actual signature. It's this new thing. The kids aren't learning cursive anymore, but those of us who know. You sign your actual signature. Alan Jackson, look, real signature. Oh, David Unetti, a real signature. And Bobby Alessi, a real signature. No, you can't make it up now. Affidavit of counsel in support of the motion to amend this order. I, David Unetti, do hereby depose and state the following is true to the best of my knowledge and belief. This is docket number 529. I'm an attorney licensed to practice in Massachusetts since December 1989. Here's my office address. On January 29th, I was retained to represent Karen Reed, the defendant, regarding the above captioned matter. Yesterday, February 26, 2025, Special Assistant District Attorney Hank Brennan called my cell phone at 4:21 p.m. I could not answer the call at the time, so I texted him with a promise to return his phone call. At 5:47, I called him back. He informed that the Commonwealth would be producing a chain of custody report. He said that we would want it for our motion to dismiss, so he wants to get it to us forthwith. I asked if he could give me a better idea of the time frame within which we would receive it. He said that he would like to have it by tomorrow, i.e. today, February 27th, 2025, but that the sergeant responsible for drafting it is retired, and it was unclear how long it would take him to finish the report. Really? He's retired? Is he playing golf? Is he out playing golf? Okay. They don't seem to be under tight timelines anyway, because the May 10th interview or meeting with Jennifer McCabe wasn't transcribed until May 29th, and then it wasn't turned over until, June something. No big whoop. He did say that he would definitely have it by the end of the week. I followed up with a phone call to Mr. Brennan today, and we connected. He informed me that there would actually be 2 chain of custody reports, both of which he expects to produce for the defense tomorrow morning. He further informed me that he would be producing on Monday morning the Sallyport videos. When I asked whether there would be new videos beyond which we already have, he replied that he did not yet know. He didn't know. Oh. No big whoop. Monday morning is March 3rd, 2025. Oral argument on the motion to dismiss is currently scheduled for March 4th or 5th, 2025. Until we receive both the chain of custody reports and the Sallyport videos, our motion to dismiss is incomplete. After receiving the outstanding discovery, because yes, they still are turning over discovery, we will need to analyze it, confer with our experts, and modify our motion to dismiss by filing an addendum. In light of the other deadlines we are working to meet in this case, including our reciprocal discovery obligations, the defense requires more time than 1 or 2 days to modify its motion to dismiss and alter its prepared oral argument. I believe it is in the best interest of justice for the court to modify the court's scheduling order to allow the defense to orally argue its motion to dismiss any day during the week of March 17th, which is, yes, St. Patrick's Day. Many of us celebrate St. Patrick's Day. It is a Monday this year, and a lot of us are Irish. Signed under the pains and penalties of perjury, this 27th day of February 2025. David Yannetti, who actually signed it with a real pen and a real signature. It's authentic. It's been authenticated. And there's that. But wait, there's more. But wait. Oops. Because the Commonwealth, beware the Ides of March. It's March 15th, isn't it? The Commonwealth has opposed this motion. Yeah, they have. So let's check that out. Hold on. Hold, please. Yeah. Okay. So here we go. I don't think I'm ever going to be able to cover another case again until this trial's over, because every single day there's so much to talk about. This is docket number 530, docket number 530. This is the Commonwealth's opposition to defendant's motion to amend the court's scheduling order dated February 10th. Now comes the Commonwealth and respectfully requests that this honorable court deny the defendant's request to continue the non-evidentiary motion hearing on the defendant's motion to dismiss for extraordinary governmental misconduct. In accordance with the scheduling order, the Commonwealth filed its opposition on February 27th of 2025. The Commonwealth objects to any continuance and will be prepared to address this motion on Tuesday, March 4th of 2025. They're ready to go. They're ready to go. Doesn't matter. Doesn't matter. He's not even addressing whether or not, he's not even addressing the fact that we still haven't turned over the videos. We're not turning them over till Monday. We're creating these chain of custody logs that we don't know when we're going to get them, because, typing is hard. And we're just going to oppose it flat out. Signed, Hank Brennan, XOXO, specially appointed just Adam Lally, Laura McLaughlin. No, nothing is signed, nor nothing. Is there an affidavit with this? No, I don't think so. Brandy Churchwell's here. She's amazing. Love you, girl. How you been? Objection, Your Honor. I didn't sign up for a circus. I can't even, There are no words. There are no words to explain the shenanigans, the tomfoolery, and the ballyhoo that have gone on and continue to go on every single day in this case. There are just no words because, and that's such a great Boston reference because it comes from Good Will Hunting, which took place in Boston. Thanks, Brandy, for your super chat. I appreciate you so much. And we need to stream together again soon. Tammy says, I don't understand this trial anymore. Where's all the evidence that Karen hit him with her vehicle? It doesn't exist. There's not even a crash report. There's not even a motor vehicle accident report in this case. I know I have claims adjusters that watch my channel. Bodily injury adjusters, property damage adjusters, adjusters who work for auto insurance carriers. Would you pay out on a wrongful death pedestrian accident without an actual police report, motor vehicle accident report, crash report, DMV report, whatever they call it in Boston or Massachusetts? I don't think so. Thank you, Tammy. I don't think so because I know that you guys have written me emails and told me. Look the Other Way will be the name of the book. Yeah, agreed, Sonia. Were the numbers shown when pulled for alternates? No, I don't think they were. Buzzing for Truth. I do not think they were, but I cannot confirm for sure or deny. Thank you, Mike Dorado, for your 5. No, you're the best. 3 blind mice. Mama, she is voting for 3 blind mice. Or, like the monkeys that are like, see no evil, hear no evil, speak no, like whatever that is. Flying monkeys. Is this situation where one could write an amicus brief? I don't know the rules. And I don't know if amicus briefs are only accepted on appellate issues in appellate court. So I don't know. I can't really opine. I don't know that there would be a third party that would have standing to do this. I mean, I know that in the motions that we saw to turn over reporters' notes and stuff, there were organizations that had standing because it was like they represent all reporters, all journalists, I should say. Mel, the prosecutors started their own AA meetings, says Alessi's Dimple. But don't worry, on Bev will side with Brennan, says Tammy. Seek, maybe a dumb question, but with all the new evidence that has come out since the indictment, is there a mechanism to review probable cause or do another grand jury? Well, they tried that during the first persecution. There was a motion to dismiss the indictments based on all of the shenanigans that went on during the grand jury, and the relationships between, certain investigators and certain witnesses and things like that. And that was denied by the judge, as was the motion to recuse. So there's that. Thanks, Anne, for thanking me. And thanks for your 20. Tammy says, can I just say that April 1st is the perfect date for this? April Fool's Day fits right in with the narrative. Poor Karen, been saying that. Yep, thanks. Captain Trips, which we could find one of these good cops I keep hearing about here in Massachusetts. Thank you for your 5. 20th Century Fox. Hi, my name is Melanie. I'm a legal secretary in Massachusetts. We do not do affidavits this way, but I bet Judge Bev will allow it. There's another Melanie in the chat, and she says we don't do it. This is not how we do it in Massachusetts. And Melanie, can the court, this is going to put any restrictions on Bev and reprimand her, or is there only remedy dismissal? Bev is in charge. She's the head MF in charge. So she is the gatekeeper. There's nobody to put any restrictions on her. She's in charge. She's got wide judicial discretion. And so there's not anybody who can come in and spank her. The district attorney could come in and dismiss the charges, but I don't think that Marcy's going to do that here. There's too much. They're dug in too deep on this one. Holy hacienda, this is insane, says Kyle. Didn't Bev just denied the defense's motion to compel the Commonwealth to produce these logs? I have to go back and look at that exact order. We've looked at so many orders recently. I think she did, though. She said that they don't have to turn over anything that doesn't exist. And they're going to make them exist. You know why? Because they don't want all these people called in as witnesses at an evidentiary hearing. That's why. Tamara, has the judge decided on the Bettero issue? Nope. Because as far as I know, she wanted Ms. Atty to supplement his affidavit. And as far as I know, that I haven't seen that filing yet. Or any issues from the last hearing. Anything that has been decided, I have already covered. So I'd have to go back and look at the docket. It's Matt. If anybody in the chat can help her, that would be great. Thank you for the super chat. Magically delish. Crafty cow, definitely some hocus pocus going on and in full clear view of the entire world. Shocking behavior. Is it though? I mean, it's just par for the course. Like yesterday when Kurt was on the stream and I was like, aren't you outraged? You're not showing any emotion. He's like, par for the course. It is what it is. It is what it is in this case, right? Nothing is shocking anymore. Nothing's shocking. That's the name of an album. Name that artist. The Misadventurous Book Mouse. They need to add that retroactive plasma extraction to MSP and prosecutorial misconduct for presenting unreliable evidence. It goes to the weight and not the admissibility, but good idea. There's so many things that, coulda, shoulda, woulda. But so little time. Could be the result or it could be the subject of another motion in limine. They did it before the first persecution. They'll probably do it again. Terry Sue, the Commonwealth should be humiliated and beg Karen's forgiveness. It's crazy town. I mean, a girl can hope, right, Terry Sue? Thanks for your 20. Kyle says they're literally creating non-existent evidence. Yeah. And, they don't know when they're going to be able to do it because the guy who's doing it is retired. So I'll be what? Yeah, they're creating it. Arts and crafts evidence. We make it up. Well done. Just when you think you can't make this stuff up, now comes the Commonwealth making up evidence. Yep. So is he producing reports that don't exist? Nope. Sounds like he's just at home on his iPad, just typing away. Maybe he had to lose his tea time today. I don't know. Loudmouth says, Bev isn't going to dismiss this case. Can they go to federal court and admit this evidence of his extreme governmental misconduct? One thing at a time. One thing at a time. We have to see what's what, whether there's a right to appeal before the trial, and other things such as like that. And why is this? Hold on. Technical difficulties. Thank you very much, Loudmouse, for your super chat. The multiple pains and one penalty of perjury, right? Pains and penalty, right? Not penalty is just one penalty. It's not a lot. It's like $5. Okay, so now the Commonwealth has new materials as evidence and chain of custody that didn't exist. Yes, Tammy, you're absolutely correct. 100% correct. Let's keep in mind that this is the second trial. Obvious corruption. Yep. Oh, we know, girl. We know. Where are we here? Thank you, Brandy. Thank you, Tammy. Nina, chain of custody log for the chain of custody logs. Yes. Yes, that's what they're going to need to request next. I stamped under the pains and penalties of perjury, Hank Breen and Anna Lally and Laura McLaughlin. Yeah. Thank you. I turned over a lot less. We were duped for your super chat. Parachutes and pirouettes. Oh, wait, Bev, the Commonwealth is creating logs that they don't have? What the duck? Aussie Insider went over possible filings to show that Karen's team could file the interlocutory appeal. Fantastic. I don't think I saw that video, but thank you for pointing it out. They have no couth whatsoever. Yeah, I would agree with that statement. I would say that is fair and accurate representation of the truth. I don't know. I can't close that thing. All right, are there more things and stuff here that we need to look at? Let me check my inbox. Hang on, because there might be more. Well, this is interesting. WBZ is reporting. And thank you, Melinda, for sending this to me, although I don't know what just happened to it. Hold on, hold please. I gotta close some of these terrible. I have too many tabs open. Quit. Okay. WBZ is reporting that Special Prosecutor Hank Brennan could make $225,000 trying the Karen Read case. Put it up on the screen. This was just published by Christina Rex at 11:14 a.m. I'm not going to play that video. WBZ first reported back in October that Special Prosecutor Hank Brennan was set to make up to $75,000 for his work trying Karen Read, and we know because we looked at the contract, we saw it, we read it together, we analyzed it. A public records request filed by WBZ reveals that Brennan's pay has been increased, and he will now make up to $225,000 for the work. Hank Brennan was hired as a special prosecutor by Norfolk County District Attorney Michael Marcy in September to try Read in her second trial. Norfolk Assistant District Attorney Alan Lally tried Read's first case and is still on the team trying her second case with ADA Laura McLaughlin. Yes, except neither of them are allowed to speak. It's like they have duct tape over their mouths. Hank Brennan's contract for the Karen Read case. Brennan is working under a maximum obligation contract, which states that his maximum pay will be $225,000 for this case. This is amended from the original $75,000. We knew he was never going to do this for $75,000 at $250 an hour. Brennan is being paid $250 an hour, which is below the going rate for private attorneys in Massachusetts. For context, according to public records, ADA Adam Lally made $145,000 in 2024. ADA Laura McLaughlin made $119,000. Well, you know what? Why don't you factor that out? How many hours Adam Lally was working, because I'm sure he doesn't get overtime if he's on salary, trying this original 10-week Mishigas, and I can bet you that he's making less hourly than minimum wage. How pissed is he right now? Who is Karen Read? Karen, 45, is accused of hitting her Boston police officer boyfriend, John O'Keefe, with their SUV and leaving him to die in the snow in Canton, Massachusetts, January 2022. Read argues that she's the victim of a cover-up involving law enforcement officers and others, and has pleaded not guilty to charges of second-degree murder, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death. Her second trial is scheduled to start on April 1st. On Thursday, the defense formally asked Judge Beverly Canone to dismiss the entire case for extraordinary governmental misconduct. And that's it. That's it. You're not going to talk about the extraordinary governmental misconduct or their excuses for same, because by the time you published this article this morning at 11:15, pretty sure that Brennan's filings or droppings, his opposition had been filed, but I guess nothing to see here. Maybe she'll do a different article on that. I don't know. I don't know. I don't know. Terry Sue, the Commonwealth should be humiliated and beg Karen's forgiveness. Crazy now. Yeah, I think we covered that before. And yeah, I could say the chances of them apologizing to her are slim and none, and Slim just got on the bus. That's my opinion. Melanie, what are the chances we get metadata on the chain of custody logs? Like slim and none. Slim just got on the bus. Thank you, Iceman, for your super chat. Marsupial magistrate on DBEV sanctions. The Commonwealth wants sanctions against the defense. Ms. Mojo Horizon, thanks for the 10. Writ of certiorari less than 1% and ruled in my favor in my case, and then they took it away. Can we get it on Bev? Less than 1%. Can we get it on Bev? I don't know. I'm verklempt. Thanks for the 10. Norma, what does all this mean to Paul's civil suit? Nothing yet. That suit is stayed right now. That suit is stayed. There's nothing happening. It's stayed until the criminal case is over. Bella Brat free, but I've said from the beginning that I didn't think that civil case was going to be successful without a police report. Please, 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 for the love of all, why can't we have the judge and counsel from the Telus trial? Thanks for all that you do. Oh my gosh, wasn't that judge the best? Refresh my memory because my memory is exhausted. She was a mashup between Cyndi Lauper and Betsy Johnson, and we were here for every minute of it. Boy, did we love that judge. Thank you, Bella Brat, for reminding me of that. I can't remember her name. Jem, I love your yellow hat. Thanks for covering this. Oh, Dancing Bears. It's my nod to the Grateful Dead and the Dead and Company as such. All right, let's stop talking about, if we could stop talking about Paul O'Keefe in the chat, that'd be great too. Anything defamatory and or about anyone in this case, whether you're on the side that you're not or not, is just not, it's just going to be deleted is all. Sorry, not sorry. Please don't do that. Al dente, could the defense have the retired detective's laptop impounded to prove or disprove prove manipulation of the video and chain of events? We don't even know if it's on a laptop. They said it was in a paper file. They said it was in the cloud. They said it was in a paper file. We don't even know if there's a laptop. Who knows? I mean, that's a great question. Probably no. I'm going to say probably no. It's probably not even on a laptop. It is so wishy-washy, muddy, mishigas at this point. Who knows? Stina J, thanks for the 5. When they amend the motion to dismiss, can they add Brennan's recent counterfactual statements? My favorite, Alessiism. They can usually add anything that's new that they did not know about during the time of the filing of the original motion. So yes, of course, they can oppose the opposition and address it in their new papers. In the new papers. Rainy day. My brother, a sergeant with the MSP, said no way would an evidence search be conducted by CERT without a crime scene services member. They document the search. Thank you. Thank you, Rainy Day, for telling us what we all were thinking. And send your brother my condolences on the fact that the rest of his brothers in blue do not seem to be or have as much integrity and knowledge of procedure as I'm sure he does. So there's the one. Somebody said, show me one good cop in Massachusetts. Sandy B, so the retired cop that left the station to retire is producing a report of chain of custody, a video he left on a hard drive at the Canton Police Department through today. He is literally making it up. Yes, that's true. Ms. Holmes, how can he now explain that they do have logs and more discovery when they just said they don't have either because they're making it up? I think we addressed that. Thank you, Mary. Thank you for your super sticker. I mean, I don't even know. This episode is overflowing with information. It is so overflowing. It is like, we need to call a plumber. AJK, this episode is overflowing with amazing information. Looking forward to watching again and reading between the lines. I mean, I'm verklempt. Like, I don't even know what to say anymore. Like, I don't even know what to say anymore. Who knows what else is going to happen before the end of the day, before close of business today. It's only 1:20 here on the East Coast. Thank you, Mama She, for your $100 Cash App. It says, for this requires something stronger than wine. I appreciate you so much. You're the greatest. You are the greatest. Okay, got that. Got that. Thoughts, questions, comments, concerns. Thank you, Donna, for your 3 matcha lattes. She says you deserve something stronger, and thank you. Appreciate you. Oh, let's go. Let me show you guys the new merch in case you weren't here yesterday, because you may know the lore. You may know the lore. Why won't whatever's on this second screen close its damn self? Hang on. How do I need it. I need not only just a tech person, but I need like a whole tech department, like a tech department. Why is Zoom even open? No, don't open, close. Close. Okay, we did that. We did 529. I think we're up to 529 and we have looked at all of them. All right. So for those of you who know that I was in Cancun for Dave Matthews and Tim Reynolds, and I don't know, sometime in January. And Some of you were with me because we live streamed a bit, and you guys some of you loved Dave Matthews, and so you were there with me in Cancun, and it was really fun, and we had a great time together. And those of you who know that a year ago, I think it was in February though, I was also in Cancun for Dave Matthews on the beach. They go there every year and do like 3 shows on the beach, and it's really fun. It's like a destination concert event. And Alan Jackson was doing a hearing one day in the Karen Reed case, and he had a bracelet on that was like this cool rope bracelet. And I said, "Oh, that's like a cool bracelet. Looks like something I got in Cancun at Dave Matthews. I wonder if Alan Jackson went there." And that morphed into this crazy Twitter rumor that I was in Cancun with Alan Jackson. And then one day, when Grant Smith Ellis was outside the courthouse with his little phone camera and his little microphone, he chased after Alan Jackson. I swear to you, it's on video. I don't know where the clip is right now. And he shoved the microphone in his face. He got one of the greatest trial lawyers in the country in front of him. And you know what his question was? "Alan Jackson, did you have fun in Cancun with Melanie Little?" And Alan kept walking. And then he chased him up the courthouse steps and said it again. "Alan, did you have fun in Cancun with Melanie Little?" Or something like that. And so we now have merch. If you know, you know. The merch is, "I went to Cancun with attorney Melanie Little." Yes, 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 you did. Some of you were there. We've got merch for that. Some of you actually were there this year when we went. I'm going to pin it in the chat, the link, if you're interested. And there's also another cool design. So this comes in a bunch of other products and things and colors and stuff, and it's fun. Hang on. Let me just pin that in there. So there's that. I went to Cancun with attorney Melanie Little. There's a little nod to the Grateful Dead in there. There's a little skeleton in there. Cute, right? And here's the sticker version of it. So you can see the design in all its glory. And then there's some cool, there's mugs, there's like women's shirts, all different colors. I will tell you that it is not Amazon. You can't get it in 2 days, but it's cute. And then we have another new design, which is here. And this shirt, there's other merch too. It says Free Karen Reed on the front and the upper left chest. Then on the back, it's got a stay cool, stay kind, stay classy. We are outraged on the front, on the top, attorney Melanie Little on the bottom. So the link is pinned to the chat. If you need some merch, I think it's pinned. Did I pin it? Yeah, I did. It's pretty cool. So many of you bought stuff yesterday. I don't mark this up very much, so it's like I make like $1 on a sweatshirt, but I just thought it was fun and Free Karen Reed and for all of your needs. This one also comes in some pretty cool pinks like this. This color pink, this color pink, and then that is the back of that one. You can get purple. And then there was another, I will say that Bella and Canvas has the best sweatshirts. Those are going to be the most soft. And those are the ones I recommend the most. There's also a mug, and then there's also this premium hoodie, which I think is cute. A lot of people ordered this one. A lot of people like this color pink. So they're a little bit more expensive, but they're also worth it because they're soft and they're organic. So there you go. How fun is that? So fun. All right, back to the chat now because everyone needs a breath. Oh, thanks, Michelle. Michelle is an RN. Attorney Melanie Little equals integrity. That's why I love you, Melanie. Oh, Michelle, I love you too. Thank you. Thank you so much. Abacus Flinch was watching Christina Rex on YouTube reviewing the Karen Reed dismissal motion with a local attorney. Both seemed to be begrudgingly admitting the conduct was pretty egregious. I think the tides are turning. I don't think so. It's wishful thinking. I don't know. Is that the TikTok attorney? I don't know. Note my objection, I think. I don't know. I'm sorry. I don't know her real name. Is Christina Rex an attorney? I don't know. It'll say which ones are Bella and Canvas in the item description. I'm not really sure off the top of my head. You have to kind of go through the products and check. But it will say in the description, it will say Bella and Canvas. Canvas? That's what it's called, right? Bella and Canvas. Yeah, so that's fun. I'm open to suggestions on merch slogans. So, feel free to put them in the chat. Cool stickers. Yeah. Like the stickers. It'd be cool as a magnet too, like a car magnet, but they don't have those. They don't have those. Oh, Christina Rex is in law school. Okay. All right. I'll allow it. I don't know that the tides are turning. I mean, you can hope, but I mean, if this is allowed to like keep going, it's just horrific. Let's see, what is this? There's a reply to the habeas petition, and I may forward this over to Kurt at Uncivil Law if he wants to go over that with you. He's the appellate guy, and he does it without emotion. So he can explain the law to you without emotion. I've got the emotion. That's why you're here, maybe. David says, I don't care for any of the parties involved. Far too much drinking and driving, misfits, incredible reasonable doubt. Karen Reed is factually innocent. Free Karen Reed, says David. I agree. All right. You know what I'm going to do? What I would do if I were you? What I would do if I were you is I would hit the subscribe button. I would hit, because it's free, I would hit the notification bell and I would make sure that it is set to all notifications. So order a men's size. I mean, order men's. I think the men's go up to like 3X. I prefer men's sweatshirts anyway. When I order hoodies, I usually order men's or unisex or whatever. You can do it, Elizabeth. You can do it. I'll allow it. What was I saying? You're going to make sure you want to make sure that you have all notifications set, because I realized the other day when I was like, Natalie the Lawyer Chick hasn't put out a video in a long time. And then I went to her channel and she had a bunch and I didn't have it set to all notifications. They were like personalized. And so I missed a whole bunch of stuff, and you don't want to miss anything, because when I go live, sometimes it's like I'm going live in 15 minutes, be there or be square. So there's that. Oh, Olivia Niles says it all. Hang on. She did send me something. Let me just take a look. Oh, she was talking about Brennan's. She posted it 3 weeks ago. Olivia posted on Twitter 3 weeks ago, the pay increase, and Christina Rex basically copied that, maybe, and put it in her article today. So, Olivia's always on top of things. She's on the cutting edge. She's always on the cutting edge, and you know it. If you know, you know. Right? If you know, you know. All right. Until the next time, which may be later today. Thank you to the moderators for keeping it classy as much as we can. The merch link is either pinned to the top of your chat, or it is in the video description, or go to my main page and there's like a tab for store. You can go to the store and find it there also. Okay. All right. Stay cool, stay kind, stay classy. I've got merch. It's Strange Credulity. There's merch for that too. Free Karen Reed. Got it. I'll see you real soon, my friends. Peace. Try and enjoy the rest of your day. Don't try to keep the gaslighting to a minimum. Goodbye. Make sure you have notifications set on your phone. That's another issue too. Some of you are like, I've done everything to get notifications and I don't. Make sure that you have it enabled on your phone to get notifications from YouTube, because that could also be an issue. Peace out, my friends. I'm going to see you real soon.